Thank you. Okay, welcome to the third hearing of Portfolio Committee number 5, Justice and Communities, for the additional round of budget estimates 2025-2026. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us here today. My name's Sue Higginson and I am the acting chair of the committee. I welcome Minister Washington and accompanying officials to this hearing today. The committee will examine the proposed expenditure for the portfolios, families and communities disability inclusion. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome all and thank you for making time to give evidence. Minister, I remind you that you do not need to be sworn as you have already sworn an oath to your office as a Member of Parliament. And for all other witnesses, as you have previously been sworn before this committee during this inquiry, you are not required to be sworn again. Today's hearing will be conducted from 9:15am to 5:30pm. We are joined by the Minister for the morning session from 9:15 to 1pm, with a 15-minute break at 11am. In the afternoon, we will hear from departmental witnesses from 2pm to 5:30pm, with a 15-minute break at 3:30pm. During these sessions, there will be questions from the opposition and the crossbench members only, and then 15 minutes is allocated for government questions at 10:45, 12:45 and 5:15pm. We will now begin with questions from the opposition.
Thank you very much. Welcome, Minister, and to all the officials. Minister, how many children are currently in HCEAs?
Whilst I work out that number, thank you for the question, Ms McLaren-Jones. It is, I will say that, just so we're clear about what we're talking about, high cost emergency arrangements, they are the placement that we have been driving down the numbers of the children in those types of placements. We've got, in the high cost emergency arrangements now, we have only got accredited providers providing that care, as opposed to when under
Minister,
a former government there were unaccredited providers.
Minister, we're now 2 minutes in. If you haven't got the figures, I'm happy to move on. And you can take it on notice. The
current figure as of 31 December last year for children in high cost emergency arrangements is 342, which is a 35% reduction since its peak, and it's under our government. We have been open and honest about the challenges that we inherited in the broken system that we are now trying to fix.
Minister, just to confirm, so HCEAs that you record are individual placement agreements, IPAs, short-term emergency placement STEP, interim care model, ICM, and special care, is that correct?
Yes, I believe so. What importantly that list does not include now is the alternative care arrangements where children were being placed in hotels, motels and caravan parks with unaccredited providers, a situation where we saw hundreds and hundreds of children going through those types of placements under your watch when you were in government.
So, Minister, just to confirm, you're saying there's no ACAs?
Correct.
Yep. So at the moment there is no child in a motel or caravan park?
Correct.
Minister, are you aware that there are children currently staying in places like the Highway Motor Inn, the Town Beach Motor Park at Port Macquarie, the Armadale Tourist Park, which is a caravan park, along with Moon River Motor Inn in Kempsey? Minister, are you deliberately placing these children in ACAs, caravan parks, motels, and calling them placements?
Ms McLaren-Jones, if you have any evidence of children being placed in those settings, I'm interested to see them. Because I've made it very clear to the department, and it has been, and my advice is that there are no children in placements that are with unaccredited providers in hotels, motels, and caravan parks, because we worked hard to remove those types of placements because they were so unsuitable for
Minister,
children.
I'm asking again, and I have been given evidence, including invoices, confirmation that there are young people staying in these caravan parks and motels across New South Wales. Now, it may be that you have not been advised of this, and I ask, would you like to take that question on notice?
Ms McLaren-Jones, I don't accept what you are saying unless I can see the evidence, and I know that you have written to me on a number of occasions about a lot of important things, and we take on board what you say and we come back to you. If you can provide me with evidence about the allegations you are now making, I'm happy to look into it. But what I'm saying is that we don't have children in hotels, motels and caravan parks with unaccredited providers because we worked hard to get rid of those types of placements.
Minister, can I ask your officials to answer that question? Is there any children staying in caravan parks or motels in New South Wales?
I would affirm the Minister's answer completely, and the key point being that all children placed are in accredited placements.
The question is whether or not there are children being placed in motels and caravan parks.
So I'm happy to respond to the question, Ms McLaren-Jones, also as an official. There are no children in high-cost emergency arrangements that are placed with unaccredited providers in a hotel or motel.
I think you're deliberately not answering the question. I'm asking, are they sleeping in motel rooms and caravan parks?
Just one moment. If everyone could just hold, I'll just hear the point of order.
Chair. Look, just in terms of the documents that Ms McLaren-Jones was alluding to earlier, I'm just wanting to clarify if she's seeking to table those.
Happy to table them.
Yeah.
I've got to just remove the what might identify a child in that room, but yes.
Yeah.
Yeah.
Okay.
This is
More than happy to table it.
The officials.
Yep.
Just and from procedural fairness, like obviously the witnesses need to be given a copy of them as well.
Yeah, okay, so just on the point of order, I hear what you're saying, but
Yeah.
Ms McLaren-Jones is not currently in a position to table them just
No, I
yet.
just want to
She
So,
held them up to the screen, so
Yeah.
I'm not sure why. It's
well,
an issue.
there's probably a
more than happy. These are photos taken of
Bring
caravan
these
parks and motels and the bedrooms. So more than happy for you to have a look at
Okay,
that.
Can I further to the point of order?
Yes.
Can I suggest
We'll
that
table
it
this.
is procedurally unfair and probably doesn't help either side in this to have the material for one side not to have it. Maybe we could have the material made
I'm
appropriate.
happy to uphold the point of order. I've just said I will table it.
Then
They're not
move
actually-
on to maybe
Yeah.
suggest moving on to additional questions. Then come back to this.
Well, no, I don't. I take the point of order. The member has said that she will table the documents. There is no point of order in relation to the line of questioning. You can carry
The
on.
Minister can't
Thank
see
you.
the
I was
document.
actually asking specifically whether or not there are children sleeping in hotels, motels and caravan parks across New South Wales.
So, Ms McLaren-Jones, the full answer to that is we have 13,500 children and young people in out-of-home care. In relation to the 342 children that are currently in high-cost emergency arrangements, none of those children are placed in a hotel or motel with an unaccredited provider as per the Minister's ban, and her response is no.
So you just confirmed that they are staying in hotel, motels and caravan parks.
No, there are no children in the high-cost emergency arrangement cohort, so the 342 children that the Minister responded to your question on. None of those children are placed with unaccredited providers in a hotel or motel.
But they
or a
are in hotels and
non-home-like-
motels.
or in a non-home-like environment. So there are a couple of, for instance, they might be in Airbnb, they might be in a cabin, for instance, that is still a home-like environment. It may be located at a caravan park, but in relation to hotels and motels, to be very clear, 342 children in the high-cost emergency arrangement cohort are not placed in a hotel or motel or an unhome-like environment with an unaccredited provider.
Ms Dean, I do remind you that you're under oath, and I asked you specifically whether there are any children currently sleeping in motels, hotels or caravan parks. You just said there are some that are in cabins. Now, have you deliberately not provided that information to the Minister, or has the Minister been misleading the House?
No, we're very clear in relation to the type of accommodation that children and young people in that cohort are currently placed in with accredited providers, that it is to be a home-like environment. I'm sure there are many children who go on holidays with their carers to a cabin and spend time in those arrangements that are home-like environments. So our absolute intention, as per the Minister's ban, is to ensure that children and young people are placed with accredited providers in a home-like environment.
A lot of us have stayed in caravan parks over the years, and they are lovely for a holiday, and there's no reflection on any caravan park here. But what I'm highlighting is that the Minister for the last 2 years has been saying that no child will be staying in a caravan park, and what has now been confirmed is in fact there are children staying in cabins with rotational staff. Now, again, Minister, did you intentionally mislead the House and this committee when you said that you had no ACAs operating and children were not going to be sleeping in caravan parks?
Ms McLaren-Jones, I think there's a fundamental misunderstanding here.
I think it's quite clear. A caravan
Point
park
of
is
order,
a caravan
Chair.
park.
Point of order. The honourable member has made quite a serious accusation that the minister, quite a serious accusation that the minister is well within her rights to answer, and she's been interrupted about 10 seconds into her response. It's a very serious accusation to accuse the minister of what Ms McLaren-Jones has. So I think the minister ought to be given the time to answer the question.
Yeah, I uphold the point of order. I think the Minister was about to answer the question.
Thank you, Chair. There seems to be a significant misunderstanding about the difference between what exactly we have banned, which is alternative care arrangements, which proliferated under your government, where children were being placed in the most unsuitable settings, hotels, motels and caravan parks with unaccredited providers. What that means is that those providers had staff that were labour hire. They were often 10 doors down from a motel room where a young child was sleeping. What we are ensuring now is that every child in a high-cost emergency arrangement is in a home-like setting. There is no child currently in a motel room or a hotel room. What we are ensuring is that they are in home-like settings, not with their labour hire staff 10 doors down. We are in accredited settings, which means that the child-safe settings apply to those providers and the care that they are providing to those children. So the evidence that we have all given today is really clear, that there is no child currently in a motel room or a hotel room, and the idea that we are hiding.
I might move on. Your officials have actually confirmed there are children currently staying in hotels, motels and cabins, which are caravan parks. Now, Minister, I'd like to move on in relation to the staff, and you talked about the staff.
Sorry, can I just... Sorry.
I think it's important that the witnesses be allowed to clarify that statement from Ms McLaren-Jones. It's a very gratuitous statement, and I think they ought to be able to respond to that.
Yeah, I am. There is something in the point of order. There really is something in there. There's.
I'd ask you to withdraw the comment. If you want to move on, I'd ask you to withdraw.
Well, I think.
It's a serious accusation.
Yeah,
This is budget estimates. We're asking questions. The minister,
wasn't a question.
The minister answered first up saying there were no children. Ms Dean had said they were staying in cabins. We're trying to get to the bottom of where these kids are actually sleeping at night and who is looking after them.
And
Well, point of
therefore
order,
you make a
Chair.
statement.
Okay, I think I've heard enough.
Should be able to
I do
respond.
think I've heard
I
enough.
know you were
and
running
thank you.
interference because you don't want her to answer. She doesn't know the
I
answer.
do think
To
that.
gratuitous
Okay,
accusation.
to the point of order, I do think I've heard enough. I think that Hansard and the record will be able to reflect what is clearly happening. The questions are being answered with the most accurate information clearly available, and the member is making accusations that will stand on the record, and people will be able to judge for themselves based on the evidence
I'm happy to
recorded
move
in
on.
Hansard. Thank you.
I'll move on to another area.
It's a serious accusation.
You can do it during the
It's a
government
serious
question
Point of
time.
order then.
No,
How
that's
is
your
it procedurally fair for a member to not ask a
This
question,
minister's quite
but to
capable of looking
summarise
after herself.
something that she alleges, and then not to allow the minister to respond to it.
I think this is budget estimates. The member can make statements, and they are on
Budget
Hansard.
estimates, the member's supposed
And-
to ask questions.
Please don't point your
not
finger
make
at me, Mr.
statements.
There
Brunos.
have been plenty of questions asked and answered in an incredibly professional, accurate way, and the record will reflect that. I ask everybody
Sure.
to control themselves, and we'll move on.
Thank you very much. Minister, how many for-profit providers are currently holding contracts with the Department of Community Justice to deliver out-of-home care services, including residential and emergency placements?
That's a figure that we may have at hand, and we'll just see if that's available to us. But I will say clearly that I have been very upfront about our government's commitment to reducing any profiteering that is happening in this sector, and particularly in the out-of-home care program. We could not have been more open and honest about the issues that we faced.
I'm sorry to interrupt, but time is limited. If you don't have that at hand, I'm happy for you to take it on notice, because I can actually refer to your answer in the last budget supplementary, number 18. And you stated that on the 13th of August 2025, 6 of the 19 properties this is just for IPAs, were for-profit organisations. Minister, could you or your department confirm that Maple Youth Services, Pontum Housing, Interactive Community Care, Big Brown House, Little Brown House, Aspire Housing Australia and Pegasus Community Care are the 6 providers?
I'd have to take that on notice.
That's fine. Minister, Interactive Community Care on their website actually advertises that they have able to provide alternative care arrangements, so ACAs. Are you aware of that?
No, I'm not, Ms McLaren-Jones, and if they are providing them, they're not providing them in our state.
Minister, since you became the minister, there's been an increase of around 50% in the use of IPAs and around a 20% increase in residential care. Now, Minister, I go back to my original question around the use of ACAs. Have you deliberately removed that line item and have placed these children in what you, which are called IPAs?
No, Ms McLaren-Jones. What we have done is work incredibly hard and to reduce the overall cohort of children in high-cost emergency arrangements by 35%, whilst also banning the alternative care arrangements from the system altogether, a scenario that was entirely unacceptable. And so that was the first work that we did, was to focus on the worst part of the system first, which was
You haven't banned ACAs, you've just changed the name
That
and
is
they've
not
called a
correct.
different placement. These children are still in hotel, motels and caravan parks.
And the evidence that has been given today that you have incorrectly placed on the record and characterised incorrectly for the record, the evidence given today is not that there are no children with unaccredited providers, and there are no children in motel rooms. All children in high-cost emergency arrangements are in home-like settings. The difference being that we've got multiple rooms, we've
Minister,
got kitchens.
is a motel room with a single bed a home-like environment? Where's the carer staying? Are they sitting
Ms.
there watching the
McLaren-Jones.
child, or are they outside staying in another motel room?
Ms McLaren-Jones, I feel like I've fallen through the looking glass. You aren't hearing the evidence that we are giving.
The evidence is that they are staying in
giving
motel,
is that
hotels and cabins.
The evidence that we are giving is that there are no children in motel rooms. And it feels like we are through the looking glass, because this is a system that you are suddenly being critical of, and yet under your government you set it up. You set it up at a situation where
Minister,
these kids were
is
in
the
those
New
placements.
England Motor Lodge and the Westwood Motor Inn motels?
Ms McLaren-Jones, it could be the case that there are children in home-like settings, in apartments.
So motel rooms on their own is a home-like setting.
That is, and what the evidence is clear that we are giving today, and you don't seem to want to hear it, that there are no children in motel rooms they are certainly not placed on their own. They are in home-like settings where there are multiple rooms, where carers who are accredited providers, so subject to all the child safety requirements, unlike in the alternative care arrangements.
Minister, how many of these
there are children
for-profits,
in
Minister, how many of these for-profits are managing these motels, hotels, emergency placements?
Well, you've asked me that question and I've taken it on notice, but I will say that we are doing everything we can to remove for-profit providers from the system. However, I will also say that sometimes the complex needs of these children are so great that
Minister,
there are...
can I ask about the staff that are used for these
Chair,
for-profits?
can the Minister possibly be afforded the opportunity to answer a question? She's just been
takes them on
interrupted. She has just been interrupted, as I have just been, at least 3 or 4 times in those responses. So I just ask you to afford her the opportunity. She was literally mid-sentence.
Yeah, I think it would be good to let the Minister finish. Thank you.
Thank you, Chair. The complexities involved in some of these cases require the expertise of the providers that are still in the system. We have to build capacity in the not-for-profit sector and within government ourselves to be able to provide and cater for those children's complexities. It is it's always the decisions that we are making are being made in the best interests of children. And at this point in time, what we have is the need to retain some of these for-profit providers, particularly when they provide allied health services that aren't available elsewhere.
Thank you, Minister. How many ex gratia payments have you authorised?
I will take that on notice, but I will say ex gratia payments are very, very rare. But I'll take the exact number on notice.
Could you also advise for what reasons and the amounts that have been approved, and also the locations, the districts?
I can provide that to you on notice. Again, I'll say that these are very unusual and rare decisions that have been made, and they are necessarily very complex.
And can you also advise whether or not any of those payments have been made to individuals or involves individuals that are known to you?
I can advise that there are no ex gratia payments that I've made to individuals that are known to me.
Thank you. Minister, can I please turn you to the Ombudsman's report on the 6th of February looking at the risk of significant harm, and that recent report into the investigation into DCJ's practice of closing those Roche reports. And the Ombudsman found that DCJ had failed to meet its statutory responsibilities constituting maladministration. And clearly, as you're aware, the findings were particularly in relation to the notion that reports were closed. And in 24-25, that was 65% of screened Roche reports were not allocated to a caseworker, and it was closed with the label "no capacity to allocate." And this was an increase of 60% from the previous year. The cases included instances of children in situations of malnutrition, substance abuse, domestic violence, and sexual abuse. Can you update what you've done, what's happening, whether the 28-day arbitrary timeframe has now been removed, and what your approach to fixing this dreadful problem is?
Thank you, Chair. The report by the Ombudsman, the findings and recommendations are obviously incredibly serious, and as we did when it was first issued, we have welcomed it because what the Ombudsman has set out in that report really demonstrates all of the issues that we have been raising since we came into government, and really reflected a lot of the concerns that we have. But I was pleased to see that the Ombudsman in his report also acknowledged the persistent nature of the problems that we are now dealing with, alongside the significant reform work that the department is already undertaking. So we are addressing it on multiple fronts. I would say broadly in terms of responding to the Ombudsman and the specific recommendations that he's made. That's currently considering all the recommendations, and we're going to be formally responding, I think in May. In April, I'm told, to the specific recommendations. But broadly, we recognise the importance of the recommendations, and like many of the other oversight reports that we've received that have all been scathing of the system, we see them as clearly setting the case for change, as well as helping us map a pathway forward. So we've already underway is a significant reform piece on the prioritisation, allocation and triaging of cases. That important work is already underway, but critically to the conversation around the ability to see children is the importance of getting more caseworkers on the ground. So that's part of our work over the past 2.5 years, is rebuilding the very foundations of the system, including valuing our caseworkers, and that's part of the $1.2 billion in the last budget. $191 million goes towards increasing salaries and support for our caseworkers, so that we can start having more caseworkers on the ground, so that they can see more children, because we do appreciate that that is a number one priority and a core responsibility of our government.
Thank you. Just on that, I'm just going to digress. I want to come back to Rosh, but just given you've mentioned that, and I know how important this is, the introduction of the new Child Protection Award, caseworker salaries in the government sector are set to increase between $100,000 and $116,969, and the Department of Communities and Justice is creating 100 new leading caseworker roles with salaries of up to $125,000. It's been brought to my attention that this is more than 20% what similar caseworkers earn in Aboriginal controlled organisations, and I'm just curious, firstly, if you're aware of this, and what actions is DCJ taking to ensure that ACOs can recruit and retain appropriately qualified and experienced staff?
Well, as Minister, obviously we're responsible for our own workforce, and what we saw in our own workforce was caseworkers walking out the door. So we have taken the steps we needed to take to ensure that we could strengthen our own workforce and ensure that they felt valued and respected for the first time in more than a decade. In terms of ACO workforce, that's the way that they are managing their own organisations is a matter for them. I will say that we are investing in ACOs more than ever before. Our family preservation program is increasing the investment in ACOs by 40% of that program will now be going to be awarded to ACOs. And as part of our new out-of-home care strategy, that's going to see significant investment, prioritising placement of Aboriginal children with ACOs across the state.
And this is the strategy you released in the last couple of days.
Correct.
Yeah. Thank you. So just really the point of my question really was there is alignment, I'm assuming. It really is just about, look, this is good, we're investing properly, we're respecting caseworkers, we're advertising and paying people what they deserve, or, well, it's close to perhaps what they deserve. But there is an awareness, isn't there, that ACCOs are in this same position and they can't, you don't control what ACCOs pay caseworkers, but there's this need for parity. That's something that the department clearly must have front and centre.
Well, there is also a distinction I'd like to make, because the caseworkers in the department undertake statutory casework, and our NGO partners do not, whether they're ACCOs or non-ACCOs. So our caseworkers undertake significant and make significant decisions as they are required under the law in terms of the child protection assessments and the safety and risk assessments. Those are all roles and responsibilities that are not outsourced. So in many ways, I would say that the responsibilities that sit with our caseworkers is now reflected in the salaries that we have now increased for them. So because it reflects the nature of the work that they do.
Thank you. Going back to Roche, so what do you say about the 28-day arbitrary report? Has that been dealt with?
Chair, I appreciate where the Ombudsman is coming from on that, and it's just the very nature of the complexity of this whole part of the system where it's very difficult to do anything really quickly, and we've got to understand what the consequences of doing that will be. So that's something that I know, I see Mr O'Reilly wanting to jump in on this one, but and I would be keen for him to do that, but it's just we will be responding to the Ombudsman
but does
by
that,
April.
for me, when I read, when I was going through, have you met with the Ombudsman?
Yes.
Great.
Yes.
Recently?
Yes.
And because when I went through the report, the 28-day hard arbitrary line would appear to be an actual cause for them problems. It puts workers in an impossible situation, doesn't it? It's like, because as you say, there are things that can't be achieved within 28 days perhaps, but if you've hit that threshold, then you're compelled to classify something and you're put in arguably an impossible position. So are DCJ workers currently now given the discretion to say, look, the 28-day arbitrary threshold is not something that marks failure or performance?
On the specifics of that, I will ask Mr O'Reilly to respond.
Yeah, thank you for the question. While the Ombudsman was undertaking his review over a long period, DCJ was also undertaking a review of triage and allocation policy at the same time.
Yeah.
That was very transparent to the Ombudsman. We have been preparing changes to our triage policy and practice, which will be ready to go very soon. And that's where we will pick up that issue around 28 days. That's where it will be dealt with.
So it's fair to say the 28 days is still there at this point in time?
It is, yes. Okay. And it's about to be removed through that triage reform, and we have to be careful about it because you might recall from the Ombudsman's report there was not just issues around that policy setting, but there was questions raised about a culture of closures. So until we really get underneath that and understand that fully, we shouldn't make rash decisions about changing until we understand what that culture of closure is about.
It almost seemed, the way I read it, and look, I'm not there, you are, but that culture and the 28 days seemed inextricably linked.
They are linked, but it requires, and the Ombudsman has deliberately given us 2 months to consider the findings and come back with advice to the Ombudsman about how we will address each recommendation and how long we think it will take, because I think the Ombudsman is recognising the complexity and the risk of unintended consequences if we make rash decisions today. So we are working on how and when we remove that policy setting and how we address the other issues identified in the report. And in the next weeks and months, we will start making those changes live.
And so, Minister, your the things that jumped out to me, and I'm sure they did to you, this idea that there are competing interests and priorities compared to somebody, a child who's at risk of significant harm. It just seems unfathomable and unreasonable, doesn't it?
Yeah, so I'm sorry, Chair, I just want to be really clear that we know we're not seeing enough kids. We've got this policy that has taken years to develop, which reflects the enormous complexity of this whole part of the system. But the reality is, if we haven't had the capacity to see a child in 28 days, it's unlikely that we'll have that capacity in 30 or 32 days at this point in time.
Right.
Hence the importance of the work that we're doing in terms of recruiting caseworkers and making sure we've got enough people on the ground to be able to see children, alongside ensuring we've got the settings right so that we are seeing the right kids at the right time. That's what this new policy is going to be about. And obviously, the Ombudsman's recommendations are being considered closely because of the importance of the impact of what he's highlighted.
Given he made really significant findings, and there's maladministration findings and so forth, is the department considering? Or do you think you're in a position where you need to take legal advice about how to discharge statutory obligations and the staff? Have you received legal advice, or is that something you're considering?
We certainly had lots of conversations with the Ombudsman about our role and the persistent nature of the issues that are being dealt with. You raised the closed due to competing interests or no capacity to allocate, which has been this, I think Mr O'Reilly just referred to it as a culture of closures. That's something that we must overcome, and we must, there is a real need to ensure that we are recording our decisions appropriately, and the system as is, we just haven't given the caseworkers the tools to be able to record the important decisions that they are making. And I've been in settings where cases are being considered and a lot of conversations are had about whether the actual safety and risk issues around that particular child. And then that case might be closed due to competing interests because they've been referred to another organisation, because they've been given the supports that were considered best for that family at that time. But that isn't an option in our current system to record that in a way that is seen and could be picked up in the Ombudsman's report. Am I saying that's a good thing? It's not. But I want to give some assurance to the committee that our caseworkers are making many decisions and taking a lot of factors into consideration about the ultimate decisions they're making as to whether a statutory response is the right response at that time.
Can you provide guarantee or assurance that in no way would any response seek to lessen thresholds about risk of significant harm?
I can give that assurance to the committee that that is not being considered.
Thank you. Minister, and I will come back later this afternoon to talk a little bit more about the details of the Roche response, if that's okay. Last estimates, Mr Tipple confirmed that work led by Snake, nationally involving you, Minister Washington, is progressing towards the establishment of an Aboriginal Children's Commissioner. And Mr O'Reilly also said that establishing minimum requirements for such a role with other states and Aboriginal peaks would mean this process would take some time. Can you provide any update and where we're at here in New South Wales?
Well, we are still in a position where we're considering the possibility of an Aboriginal Children's Commissioner in New South Wales. The conversations are being had in good faith with the Commonwealth and the Aboriginal Leadership Group as part of the safe and supported conversations to land the minimum requirements. That is unfortunately still an ongoing conversation. We have done our best. We felt in that forum.
Do you feel that, like, I mean, ACT in South Australia went ahead and put commissioners in place. Is there a reason why we're not being part of that? I totally understand and admire the desire to have that national framework and those standards, but is it also a case where at some point you've got to just commence and start?
It is complex. I want to make that really clear. We've got a myriad of oversight bodies that are involved. We've got the Ombudsman that we've just been talking about, the Auditor General, Advocate for Children and Young People, Office of Children's Guardian, all of which have their own statutory oversight responsibilities. It is to make any changes in that area is going to be a long piece of work. It is, and as the committee is well aware, there is so much work happening in the department at the moment to try to address the issues in the system that we inherited, that when it comes to oversight, we are seeing a lot of reports, and since I've become minister, there's been a lot of oversight reports landing on my desk.
Can I take it that you're not particularly committed at this point to establishing a commissioner's role?
I'm just saying it will be something that we consider once we can land the minimum requirements at the Commonwealth level to determine what that might look like in New South Wales.
And so in your mind's eye, what does that, who signs off on that, and how does that happen? Where are you satisfied that the minimum standards are established?
Well, we were. Well, I don't really want to go into the the full detail of all the negotiations that have been had for that landing the minimum requirements, but we were comfortable with the form that was proposed, and I think it was minimum requirements 5, but then Commonwealth has proposed a version that's still being considered.
And is there any indication from that Commonwealth process when that time frame is?
I'm uncertain of when the next Community Services Ministers meeting is with the ALG.
Are you able to take that on notice? Is that something
Absolutely.
you're able to provide? And just based on your participation so far, do you think that at the next meeting you would be in a position where you would be advocating, hey, that's where we're at, this is a good place to land, especially given the experience from South Australia and the ACT?
Well, we have been doing that already, and we had hoped that it would land last time, and yes, definitely. In our view, it is a matter that requires resolution, and definitely at the next Community Services Ministers meeting.
Thank you.
Thank you very much. Just to go back to the ex gratia payments, I just wanted to clarify, is there a threshold amount that requires your signature?
Ms McLaren-Jones, if I understand your question correctly, ex gratia payments may only be signed off by me?
Yep, okay. That's I just wanted to clarify.
I don't understand the threshold.
No, that's what I was
question.
clarifying, that whether it's $10 or 100,000, it has to be approved by you.
Oh, sorry. I'll just to make sure I'm not misleading the committee.
No.
I'm not sure.
The minister's evidence is correct. In the case of ex gratia payments, to my knowledge, they are always subject to departmental advice, and that advice is sourced from DCJ Legal. So their care is taken to ensure that the payments are beyond reproach.
Thank you. Minister, I asked you before about whether or not any of those payments were made to individuals that you were aware of. Could I also ask that were any of those payments made by two individuals that were known to any members of your staff?
Ms McLaren-Jones, I'm uncertain of the allegations that you are making.
I'm not making an allegation, just asking a question.
I just want to be clear that the question you asked before, and you've just reframed it about whether they were people that I was aware of.
No, known to you.
Of course, I was aware of the people I was making an ex gratia payment to. They were not people that were known to me.
Exactly. That's what I was asking. I asked you if any of the payments that were made to individuals, were those individuals known to you, and you were advised that they were not known to you? As
that is
friends
correct.
Or members of a political party or any of those things?
Correct.
Yeah. And I'm now asking if any of those payments that were made to these individuals, were those individuals known to any members of your staff, of your ministerial or electorate staff?
I'm not aware of that, but certainly I haven't quizzed every member of my staff on, and these are very private matters, and not many of them would be aware that they were being made. So I can take that on notice, but there are going to be some limits as to the information that I'm even sharing, especially when we're talking about electorate office staff. They have no involvement in the work that I'm undertaking as a minister, and particularly the confidential nature of the matters that I deal with on a daily basis. That is not the realm of electorate office staff.
That's fine, but I'm just asking more broadly, just covering the question broad enough to ensure that you're able to answer it, whether or not any of your staff knew of individuals who may have been given ex gratia payments.
I will take that on notice.
Thank you. Minister, just back to for-profit providers. How many for-profit housing providers are leasing properties to the department for children who are in your care?
Ms McLaren-Jones, can you just repeat that question, please?
How many housing providers, for-profit housing providers, are leasing properties to DCJ to care for children?
I'm going to take that on notice, Ms McLaren-Jones.
Minister, how many for-profit providers with care contracts are leasing properties to DCJ?
Again, I'll take that on notice.
Minister, does DCJ require for-profit providers to disclose whether entities providing housing are owned or managed by the same directors or beneficial owners as the care provider?
We certainly have a strict conflict of interest policy, and we've seen some issues with that, and we are in some of the providers, and we have it's part of what our new strategy is all about, ensuring that there is accountability and transparency in every arrangement that we have in a future system, one that has been sadly lacking in the system that we inherited. So we have got strict conflict of interest requirements on all providers, be they for-profit or not-for-profit.
Oh, thank you. Minister, will you provide the names of the for-profit agencies that are providing care to children and also housing?
Can I, Ms McLaren-Jones, when you're talking about housing, what are you to say? I'm not the minister responsible for housing. In what context are you asking?
For-profit organisations that own properties that also have care contracts with you.
It's still unclear to me exactly what you are asking, Ms McLaren-Jones.
I'm asking for the list of names of organisations that you've got contracts with that provide care for children that also own properties that are receiving money from DCJ for those properties.
Of course they're going to own properties. I don't...
In relation to caring for children. I'm not asking about where they might have their staff housed. I'm talking about properties that they own that are receiving money from DCJ and also housing children in those properties and receiving money from DCJ.
I will take that on notice, Ms McLaren-Jones.
Thank you. Minister, how many of the for-profit providers use their own staff as part of the contract with your department?
Again, I will take that on notice.
Do all the staff employed by these for-profits have working with children check?
As a requirement of being an accredited provider, staff, as I understand, are required to have working with children's checks.
Have you ever asked?
It is part of to become an accredited provider, and I'm sure the public servants here will going to be able to provide more detail, but as part of being an accredited provider, they must meet certain child safe standards, and those child safe standards require people that are working with the children to have working with children's checks.
And is that ever audited or checked, or is the onus on the for-profit provider to, I suppose, own up?
Well, the Office of the Children's Guardian does a terrific job ensuring that there is strong oversight on every accredited provider in the out-of-home care sector, and that is part of the role that the Office of the Children's Guardian plays.
That's fine. I can cover that this afternoon. Minister, do you expect to receive an incident report each time an incident occurs at one of these for-profit homes?
Every time an incident occurs, no, I do not, Ms McLaren-Jones. If there is a critical incident...
Sorry, I should have said critical
If there is
incident.
a critical incident, as is the case for any critical incident occurring anywhere in the system, I expect to receive a briefing on it.
And how quickly are those briefings provided to you?
That varies depending on the complexity of the case, but broadly they come to me quite quickly.
Minister, when was the last time that you received a critical incident regarding an IPA managed by a for-profit?
I received lots of critical incidents and I can't recall, and I can take that on notice.
In the last week, did you receive a critical incident regarding any young person in your care?
Yes, Ms McLaren-Jones.
And when was the date of the last critical incident?
I cannot recall the specifics because there has been a number.
Did you receive one in the last 4 days?
I will take that on notice as well.
Did you receive one in the last 24 hours?
No, Ms McLaren-Jones.
In the last 48 hours?
What? I have said I will take it on notice.
That's fine.
When it is unclear to me where you were going with this, but there are, as a matter of course, a number of critical incidents that come to me regularly throughout any given week.
And Minister, just to clarify, I'm trying to ascertain whether or not you've been briefed on critical incidents may have occurred in the last week. And I'm happy that you've taken on notice. Minister, I might move on to the Waratah cottages. In your social media post of 18th of January, you say there are improved outcomes. Could you outline what they are?
It's always nice to know someone's looking at your social media.
Oh, I'm not.
Sorry. Sorry.
The Waratah care cottages are something that we are very, very proud of. And with the department stepping into the delivery of residential care for the first time in a very long time, and the important role that Waratah care cottages have played in ensuring that children who were once placed in alternative care arrangements particularly, and other high-cost emergency arrangements, particularly sibling groups, are now in home-like settings where they are getting the support and services that they need, with a view to, hopefully, securing a longer-term placement for them. But they are playing a really important role, and it is something that I've visited 3 of them before the children came, and they are wonderful. They've been set up beautifully, and they are providing wonderful home-like settings for children.
Minister, what outcomes framework are you using to determine that? Or is there one at all?
There is, I'm aware that the Office of the Children's Guardian has undertaken their own review of the program that we are offering, and the response, and I don't want to put words into the Children's Guardian's mouth, but what I understood was that there was very positive response to the offering of the Waratah Care Cottages, and of course everything that we do is evaluated, because we want to ensure that when we are investing any money in the system, that it's based on evidence.
So you intend to measure these outcomes?
Absolutely.
And how will that be done, and is there a time frame for the evaluation and the report?
I can provide that to you on notice if you would like the detail of an outcomes framework on the Waratah Care Cottages.
That'd be great, thank you. Also, what is the annual operating cost of each of the cottages?
I'll take that on notice.
Yep. Also, do you have the cost of the average cost of caring for a child in one of these cottages?
Again, I'll take that on notice.
Minister, you also claimed on your social media post of better staffing models with increased visibility and accountability. Could you outline what that is?
We have, and I think we've given this evidence before to this committee about the model of care at Waratah Care Cottages, and I don't think it's changed since.
I'm talking about staff.
Yes. Which
better staffing models. So
yes,
that's employment of staff. So I'm just interested in that model.
The model of care is delivered by staff. So we've got department, the DCJ managers of each of the homes, and we've got employees, contracted employees delivering care in the homes. I think that's accurate, and that was the evidence we gave on the last occasion as well, and it's under the same model as Sherwood.
And just to confirm, last estimates you advised that it was Pegasus that was being used for staff. Are you still using this for-profit organisation to provide staff?
I believe so. And I'll just say the really important part of the Waratah Care Cottages is that previously the children who are now placed in those home-like settings together and the sibling groups were previously split up in high-cost emergency arrangements or alternative care arrangements, living apart, and now they have been brought together in Waratah Care Cottages to ensure that they retain the important connection that they need to have the futures that they deserve.
Minister, looking at another social media post that you made, you claimed that the helpline receives over 500,000 reports, and yet the different figure on the statistical data is 114,534. Now, can you outline the difference between the two types of reports?
I believe that we are talking about two separate types of calls. The helpline receives a lot of calls, then they are screened out as to whether they meet the threshold for ROSH or not, the risk of significant harm. And then there's also another, and I appreciate that this can be quite complex, it is for me at times as well. You've got the calls that come in, calls of concern, determination whether or not they're at risk of significant harm, and then determination of how many children those reports relate to. So they're the different. I might defer to
No, that's fine. It's fine.
Public Service to make sure I'm accurately representing that.
No, that's fine.
I'm being given nods.
So whilst they're being triaged, the around 400,000 that are deemed to not meet that threshold.
I think what you're comparing is perhaps, and without the figures in front of me, is the number of children who are considered to be at risk of significant harm from that initial, the initial reports of concern that came in.
Yep. So you said on your website or you're on social media, more than 500,000 reports. So I'm estimating, just under 400,000 were deemed not to be ROSH reports.
No, that's not accurate. We have data as to the number of ROSH reports, and it's higher than that. But I think the 100,000 odd figure that you're using relates to the number of children that were subject of those reports.
Right, okay. So could you give a breakdown from your 500,000 that you claimed in your social media post? How many were actually then triaged for further assessment, and then where you then landed with your 100,000? Because I'm trying to get an idea of what happened to those other children that weren't deemed to need an assessment.
I can take it on notice, but I believe it is all on the dashboard and it is all publicly reported, because we are doing everything we can to ensure there's full transparency.
The first time I've seen this 500,000 that you put out on social media, so I'm just trying to break it down a bit better.
And it was probably a generalised a figure that was reflective of a pattern. I'll say that.
Minister, on in the August 25 hearing, I put to you that approximately 13,000 children reports were screened and waiting for allocation in just the 6 weeks. Now, you dismissed that as unvalidated data. The Ombudsman released his report several months later that confirmed that 65% of those reports were being closed without allocation across the year. Minister, were you misleading the committee at that time, or were you unaware of the extent of the problem?
I entirely refute the suggestion that I was misleading the committee, and never have, Ms McLaren-Jones. And the conversations that were had at the last Estimates Committee were difficult for us, because you were relying on data that we had not seen, and relying on material that had yet to be aged, so that we could understand the full picture, which is what happens. And as the former minister, I understand you would understand that there is an importance that we have certainty in the data that we are looking at, and ensuring that the decisions that we are making are based on facts and evidence. That
Minister, at the time,
is critical in
I was actually
everything
trying to
that we're
highlight
doing.
that there was a column about children not being seen and unallocated, and you were dismissing that. But Minister, the next thing I wanted to actually ask about is in relation to reports that aren't receiving a response, and whether or not the threshold for ROSH has changed.
I have already made it really clear to the committee today that there is no changes, and there's no anticipated or no intention to change ROSH threshold. And I will also just go back and correct again your mischaracterisation of evidence that I've given in terms of the evidence given on the last occasion, that there's no way ever that I'm dismissing anything about the number of children that are seen. I'm saying very clearly that we do need to see more children.
And just to clarify, you said that there's no change in the ROSH threshold. Can you guarantee that no directives are being given to any staff to change the guidelines around how they may consider a ROSH report?
Absolutely, and I would think that is coming from some places of deep conspiracy.
Okay, Ms. Abigail Boyd. Thank you, and good morning, Minister and officials. Just picking up on some questions that's already been asked in relation to this Ombudsman's report on ROSH, and in particular, The Ombudsman found that disability cases represented a standout issue in the case review, finding that children with disability and children of parents with disability repeatedly fell through the gaps. Were you as shocked as I was when I read this report as to how many children who are potentially really suffering are just not getting any attention when a report is made?
Thank you for the question, and I really appreciate your focus in terms of the children with disability, and particularly when it comes to the Ombudsman report. And I've got to say, there was many things I found very concerning in the Ombudsman's report, none of which was necessarily a surprise. We know that there are a lot of families that are with children with disability and that are struggling to get the supports that they need. It is an issue that I am constantly taking up with the Commonwealth in terms of the importance of ensuring that children who are entitled to get support from the NDIS are getting the support and the full support that they ought to get.
In terms of exploitation and abuse of children with disability, though, this has been since 2019 when we first, as a parliament, put in place the Ageing Disability Commissioner. I argued at that time that there was a sort of a missing cohort of people that wouldn't be covered by the ADC, and that was children with disability. And at the time it was argued that those children would be adequately looked after by other parts of the system. This is yet again more evidence that when it comes to children with disability, they really don't have any kind of independent champion for them. Did this findings in this report lead you to sort of rethink the scope of the ADC, or begin to think as well about whether or not we need some sort of independent oversight body to prevent exploitation and abuse of children with disability?
I'll be frank and say no. The expansion of the ADC is not something that came to mind. What came to mind was, what do we need to do as a system to ensure that these children are getting the supports that they need? So we've got important. Well, I want to go back to the way you framed the question in the first instance as well, in terms of the Ombudsman's report, and that the assumption that children aren't being seen, or no, there's not enough children being seen, and that's a given. But in terms of our workers responding to a report of concern, they are then making inquiries, determining what might be possible, referring families to other services that may not be recorded.
Can I give you an example, just so that we can sort of narrow the conversation, I guess? So, as reported, that there was multiple cases that were laid out in the Ombudsman's report. For example, Ella, non-verbal, with severe autism, and Claire, with 5 Roche reports made in a year. DCJ closed those reports partly on the basis that disability services or schools were already involved, yet the core concern in those reports was non-engagement with those very services. So this is someone who's, these kids have been reported because they're not engaging with school and they're not engaging with their disability services. DCJ has then closed that report on the basis that it's fine because the schools or the disability services will be looking after them. That's a very clear error being made by DCJ, not just once but numerous times as reported in this. What action have you taken to, I guess, immediately prevent that sort of situation happening again?
Well, I would say there is certainly there's a couple of elements to this. In terms of our workforce responding to reports of concern, and I appreciate the description that's been provided, and as painted, that's not okay. But these cases often involve enormous complexities, and it could be that there have been additional work that's been done with the Department of Education, for instance, that's not captured in the information that's recorded, to ensure that there is additional support being provided for that child to engage with the school. There is just enormous complexities.
Are you saying that the Ombudsman is wrong?
No, I'm not saying that at all. I'm saying that there's in every one of these cases, and we just don't have, in our system, we don't have the ability to properly record, which is what the Ombudsman was looking at, our records relating to these children, that we don't have the ability to properly record the decisions that are being made and why they're being made. And that's part of the work that we're doing now, and our change to our policy to ensure that our caseworkers can put a proper description in about what's being done to ensure there are enough supports for the families. Saying that there is work that we are doing on thriving kids.
Sorry, can we just come back to this though? Because these are clear failures of DCJ to respond appropriately to reports where somebody has raised that a child, a very vulnerable child, is at risk of significant harm. So they've made that report, and then DCJ has gone, oh no, it's fine, it'll be dealt by someone else. That has been absolutely laid out in clear detail by the Ombudsman in what I read as a shocking report that would require urgent responses. I understand some of it will require something a bit broader, but something as simple as that, as saying to people, look, hello caseworkers, next time you get something in that says this person isn't engaging with other services, that you can't then just not look at it on the basis that other services will deal with it. Did you make any of those immediate recommendations down to DCJ so that we could make sure that today caseworkers aren't making these same mistakes?
There's some very important work that has already been done and is being done right now in terms of uplift of capability and response from caseworkers. The Deputy Secretary has rolled out a Back to Basics program for our workforce to ensure that they are responding appropriately and in accordance with our statutory obligations to respond to child protection issues. That is when we are talking about cases, as you are, the people that are on the front line making these decisions, we are equipping them with the increased skills and capability and confidence to make the right decisions in those exact settings. That's where we're at right now.
I'll come back to that. I think, and let's just put it on the record to be very clear, I have a lot of respect and sympathy for the frontline workers who are doing this work. My concern is with the system, the under-resourcing, the way that incentives have been placed, the way that systems have been used to support that perhaps are doing not doing the caseworkers a service that they should be, and we'll come to that. But I just wanted to put on the record, this is not. I'm interested in the systemic failures here as opposed to the individual caseworkers who are doing incredibly hard jobs. Let's look at the case of Billy, so another one in the Ombudsman's report. This is a child with severe disability fed via nasogastric tube in a remote location, so high vulnerability. Their report was closed without the follow-up actions that even the triage caseworker had specifically recommended. What happens when that sort of thing happens? Where is the accountability for that closure? What is the supervision and sign-off process for closures in those kind of complex disability cases?
Well, this is the work that's been done on the development of a policy over more than 2 years that's soon to be implemented. That was acknowledged by the Ombudsman in his report that we have got this new way of working that's going to be rolled out shortly in terms of the prioritisation, allocation and triage. New policy. So did
the Ombudsman's report tell you anything that would tweak the work that you're doing? I think there's yes, the Ombudsman acknowledged there is some work being done to reform the system, and that's great. But obviously there are going to be learnings in here
Absolutely.
for you in the department. Is that now being used to sort of tweak those reforms and make sure that we get it right?
Absolutely. I can assure you that every recommendation and every report from an oversight body that we have received is informing the reform that's underway on multiple fronts. But an important element of this as well, and you spoke to the importance of the work of our caseworkers. A really important element of all this is what I've already shared with the committee this morning, is our work to support our caseworkers and ensure that we have got the people on the front line that can make those decisions. More caseworkers. We saw a significant decline in the number of caseworkers across our entire system, and so the work that we've done to increase their salaries, to provide additional support, mentoring, leadership training to them, is the work that is going to see better decisions being made in an environment that you described as under-resourced, yes, in terms of people actually in positions that are currently funded. We have been working hard to try to fill those positions. Thankfully, we are seeing the vacancy rate of our caseworkers turn around from a peak of 12% across the state, where it's now sitting at 7%. That's going to make a significant difference in the quality and consistency of the decisions being made. So when you ask what are we doing, that is a piece of work that we've been doing since we came into government.
Yeah, I'm just making sure that you're also taking learnings from this report.
Absolutely.
As I say, I was absolutely horrified. Can we look, though, at one of the other key findings of the Ombudsman was that the SDM risk assessment tool was built on Californian data and has not been calibrated to New South Wales demographics. And given that the disability profile of New South Wales, including the NDIS population, differs markedly from California, what evidence does the DCJ have to give you assurance that the tool does not systematically underweight disability-related risk factors?
Are you talking about the SDM risk assessment tool that we've retired, or the interim tool that we've now got in place?
That's a good question. I'm talking about the one that the Ombudsman was referring to in their review.
It's that's been a tool that's been retired.
Excellent.
An interim tool is already in place. We heard loudly from the sector, particularly from our Aboriginal partners,
Yes.
that tool was inappropriate. They had been calling for that to be retired for years, and we did it.
Okay.
And an interim tool is now in place. And the work is being done on in partnership with ABSEC and ALS on a future tool, but obviously considerations around disability and what the impacts will be on disability community will be taken into account in that work.
So what underpins, I guess, what data is underpinning that new risk assessment tool then? Is that based on New South Wales data? Is it, who's developed that tool?
I'm going to hand over to Ms Dean for that, or Mr O'Reilly. Mr O'Reilly,
Yeah,
for the intricacies of that.
The fundamental problem with the SDM risk assessment tool the OMBO identified was that it did use actuarial data to guide decisions. That is the fundamental problem. So the interim risk assessment tools do not use actuarial data. They do not use data. They actually instead move caseworkers and families through a series of questions to assess risk, strengths and vulnerabilities in families, capacity of families to provide protection and so on, and support needs.
Okay. I might come back to that.
Sure.
Can I just ask, in relation to interagency case discussions, they were identified as underutilised before closure, including in disability cases where other agencies like NDIS providers were key stakeholders. What is DCJ's current rate of ICD convening before closing reports, including children with disability? And what's the target rate?
In terms of closing, before closing, there's a lot of interagency work that goes on constantly across all of our community service centres. At what point depends on where the need is. Largely the conversations are being had around point of entry determining whether or not there are alternatives to statutory care, where we have conversations with other providers that may be able to offer alternatives as opposed to a child coming into statutory care.
Yeah. What's the what's DCJ's current rate of ICD convening before closing reports? Are you able to give me that on? Is there any target rate?
And I've got to say, ICD isn't a term that I'm familiar with.
Sorry, the interagency case discussion.
We've got safeguarding decision making. We've got other structures in place for these for conversations to be had around entry. But I can take that on notice in terms of any of those at that point in time.
Thank you. It was a key finding in the Ombudsman's report. So, hopefully there are plans to try and improve the rates, particularly for children with disability before closure. Okay, let's move on to foundational supports and thriving kids. So I understand now that the rollout of state services for thriving kids is to be by the 1st of October 26. Now, obviously, it's been a bit of a moving feast, but that's only 212 days away, which is not a lot of time. Are we on track?
Yes, and I'll just clarify that the Thriving Kids program is to start in 1 October 2026 for full rollout by 1 January 2028.
Okay.
So there's a opportunity and for us to scale up services over that period of time. And what's really important in this conversation, and to give some assurances to families of children with disability, is that the NDIS access rules will not change until 1st of January 2028.
Okay, so what does it look like then in practice? If you currently you have a package on NDIS, there's some rollout from 2026, but not a full rollout till 2028. What does that mean for an individual?
The individual will stay on the scheme.
Okay, so, but when you say that there's going to be a staged rollout, I guess which bits come in when? What's the...
Yes, and that's a good question. That's in terms of our service delivery.
Okay.
So what Thriving Kids services might look like are supported playgroups, parent capacity building, allied health, either in group or individual settings. Those are elements that may form part of Thriving Kids.
Yeah.
We anticipate will form the Thriving Kids program in New South Wales. How that's to be rolled out is the process we are now undertaking, still in consultation with the sector as to what that ramp up of services looks like over that time.
And in terms then of the spending of money on services, is there an expectation of how much money will be spent at which points in that 2-year period?
There's certainly a lot of mapping that will be done, and it's being done in terms of expenditure over that period of time.
There's a lot of confusion for families,
yes.
And it's as you know, it's been a really confusing area with the Commonwealth doing one thing and states, territories doing another for quite a while, and a real kind of uncertainty over what exactly foundational supports will look like. Will there be, before October 26, a sort of a clear timeline set out of what's going to be in place when?
That's exactly what we would like it to achieve, and because I acknowledge your description of there being a lot of confusion amongst the community about what exactly Thriving Kids is or will be. But just to be really clear as well, that the Commonwealth has guaranteed that existing families with NDIS packages will be grandfathered in the scheme. They're not going to be kicked out of the scheme, so they don't get moved into Thriving Kids.
Just until they're 9, or
Correct.
Right.
So the Thriving Kids program is for 8 and under.
Okay. Thank you.
Thank you.
Thank you.
We've just got a few minutes left over, and we'll share the time over
Thank
to
you
the
very much.
opposition.
Thank you. How many caseworkers are leaving in their first and second year of employment?
Caseworkers, when we came into government, were walking out the door at the rate of knots.
Minister, it's a very simple question. We've only got a
and
bit of time.
we have
Happy for you to take on notice if you don't have the answer.
We have stemmed that flow, I'm pleased to say. I will take on notice the exact number, but I can say there are now caseworkers, some caseworkers,
That's
who are
fine. Thank you, Minister.
$17,000.
Thank you, Minister. How many caseworkers are currently not at work because of workers' compensation claims?
I'll just complete my former answer that there are now caseworkers that were $17,000 better off
Minister, you
than they were
answered the
before
previous
under
question.
our
It was quite-
government.
Order, Chair. Point of order, Chair. The Minister's been interrupted 3 times now, I think, in the last minute.
not answering.
If she could be afforded the courtesy of being able to answer a question, that would be helpful for budget
She's already
estimates.
answered it.
All right, thank you. I hear the point of order. Let's carry on.
Thank you. Minister, how many caseworkers are currently not at work because they're on workers' compensation claims?
I'll take that on notice.
Could you also take on notice, if you don't know the answer, how many are on part-time work or part-time return to work due to workers' compensation claims?
Given that we have a workforce of over 2,000 people,
I'm
I
referring
will
to
also
caseworkers.
take that on notice.
Thank you very much. Minister, how many, in the last 12 months, I'll narrow it down, how many caseworkers have been transferred to other districts due to bullying allegations?
Again, I will take that on notice.
And Minister, in the last 12 months, how many investigations have been conducted into DCJ officers following allegations of bullying or intimidation of staff?
I will again take that on notice.
Thank you.
Thank you. Minister, can I just take you in the last remaining time I have? Community attention has been on the number of young people self-placing from out-of-home care, particularly from residential care type placement arrangements. Often those children who are absent from their placements are listed as missing persons. There's anecdotal evidence of children self-placing through bail arrangements, although the New South Wales Children's Court has recently changed its approach to this, noting the tension between their requirement to consider the Bail Act and not place children in unauthorised placements, contrary to your legislation, the Children and Young Persons Care and Protection Act. Are you aware of how many children are currently missing from out-of-home care?
I will acknowledge that this is an issue, and it's an issue that was raised in another Ombudsman's report as well, and one that we are seeking. Well, we've often these children are coming from intensive therapeutic care placements. And I'm advised that as of 2 February, there were 4 young people under my parental responsibility who are recorded as
4?
missing. Yes.
Thank you. Can I ask how many of those are, if any, Aboriginal children?
I will take that on notice.
Thank you. Is there any internal department DCJ work focused on the increasing number of young people on remand in youth detention who may also be in your care, Minister, and considering their individual circumstances and bail arrangements?
Sorry.
Is there any
Chair.
work, like are you, obviously, I know Mr O'Reilly works at probably the intersection of this work, but is there work focused on this increasing number because of the increase in young people on remand in youth detention, but also that may be in your care?
Well, there is a lot of focus on ensuring that young people in my care have the supports and services that they need. So we are we are doing what we can, but Mr O'Reilly, I'm sure, will have more to say in terms of the work.
And I will talk
on
with
that
him
front.
specifically. Recommendation 6 of the Ombudsman Intensive Therapeutic Care report released in December was that DCJ should review and identify reforms to the policy and practice standards of care for children not in placement, to provide for these children's safety, welfare and wellbeing when away from placement. Has that work commenced, or have you commenced that review? And does it include external stakeholders having input, including young people already in the system?
The intensive therapeutic care placements are an area, obviously, that was the subject of the Ombo's report that landed in December. We've got an evaluation that's starting on that program in June of this year, July this year, that will take a year. But in the meantime, we are undertaking work to strengthen the safety of children in those settings and to make sure that they are getting the supports and services that they need.
And I know we're in government time, can I just ask, so I don't come back, is that evaluation, will that involve external stakeholders being able to have input?
100%,
Great.
and they always will. And to your point, the most important voices in this are the children. And I've met with so many children that have been in different placements, particularly alternative care arrangements, and it's driven a lot of the decisions that we've made to date, and they will continue to ensure that the children's voices are heard through our reform.
Thank you, Minister. Now we are in government time.
Thanks, Chair. We don't have any questions at this stage.
And the government has no questions. That means we now get to break a little bit early and we will resume at 11:15. Thank you, everyone.
Yeah.
Okay, we will recommence. Thank you. And questions from the opposition?
Thank you very much.
Sorry, I didn't mean to interrupt. But Chair, I was just wondering whether there's an opportunity for me to update the committee on some evidence that was brought in.
Can we do it in government time?
No.
I was,
We'll have questions.
No, but that's what I'm saying. In your time, she can update.
I tell you what, if you wouldn't mind waiting, Minister, we'll let the opposition go, and I'm very happy for you to update the committee during my time.
yep.
Thank
if
you,
that's
Chair.
okay.
Unless it's going to be short.
Thank you, Chair. Much appreciated. No,
Thank you.
Take the Chair's offer.
Thank you very much, Minister. The bulk of reports that are made by mandatory reporters, and you would describe those as professionals.
Is that a statement or a question?
It's a
Ms.
question.
McLaren-Jones?
Do you regard them as professionals?
When we are talking about teachers, police, fireys, yes.
Yep.
Absolutely. Definitely professionals.
Minister, in your social media post, 27th of January, you stated, and some of those reports, and it was referring to the reports that are made to the helpline, that some of those reports can be a child turning up to school who hasn't had breakfast or who hasn't brought lunch, and a report's been made by a teacher. Are you saying that these teachers are making false reports?
I'm not saying that at all, Ms. McLaren-Jones.
Are you saying that teachers don't know the difference between a child that might have forgotten their lunch and a child that hasn't had breakfast or lunch for a long period of time and is concerned about their health and well-being?
I'm saying that that there are reports made that that don't meet the threshold at times, Ms. McLaren-Jones. But I am, and my message in that social media post, as I recall, was that we welcome reports. We want reports made so that we can understand the whole picture that relates to a particular child. Every report paints a picture as to whether they meet the threshold for ROSH or not. It assists us, and that's exactly the message that I was trying to convey in that social media post.
But Minister, are you saying that mandatory reporters don't know the difference between what is a ROSH report and what is not?
That is not the... I just gave evidence as to the message that I was giving, that we welcome mandatory reporters making the reports that they consider necessary. That then is the lens of child safety and child protection is applied by our caseworkers, and so that's how the system works.
But Minister, why would a mandatory reporter, a teacher in particular in this case, make a report to a helpline if they weren't concerned?
Well, they clearly are concerned, and I'm welcoming people, mandatory reporters and other people, to make reports to the helpline so that we can have the full picture for kids to understand what risks they may face, and then we will make a decision as to whether a statutory response is appropriate or a different response.
And what evidence are you relying on to support the notion that not every report requires a full investigation?
Because literally the hundreds of thousands of reports made to the helpline represent a whole spectrum of concern coming from community and mandatory reporters about children. And sometimes those reports are duplicate reports about the same incident or the same child. Sometimes they are about children that are already in the system where we know that they've got supports and services in place. So there's a whole multitude of different concerns that are raised with the helpline, and it is the difficult task being done by our frontline workers on the helpline every single day, trying to ensure that we are seeing the right children at the right time. And we know that we've got a lot of work to do to improve that system. The Ombudsman made that clear, and it's work that was already well underway by the department. And the evidence that's already been given today is that we have a policy that has been years in the making to work out a better way forward to ensure that we are seeing the right children at the right time, and that policy will be rolled out soon.
So if a lot of these reports from mandatory reporters don't meet meet the threshold. Are you doing work around engaging with mandatory reporters to raise awareness or educate them on what they should be reporting or not?
We have got, in the Department of Education and in the Department of Health, I believe, we have got a particular child wellbeing units who help our mandatory reporters understand what their obligations are as mandatory reporters. And both of those roles are also part of the review to ensure that they are working effectively, so that the reports that are coming to the helpline really do assist us in securing and keeping kids safe.
Minister, I might move on to plans. Are you responsible for ensuring children in out-of-home care attend school?
It is certainly a goal of mine that children of school age attend school and are enrolled at school. In terms of education plans are made by the Department of Education in the schools themselves, and we are trying to get greater visibility on each of those plans, but they aren't held by the department, aren't done by the department, and they are held by the Department of Education.
That's a similar answer, previous estimates, that you're still working with the department to get a better understanding of the education plans and how many children have them and don't have them. Where is that up to now?
I'll have to get some advice from Mr. O'Reilly can update us on that.
Yeah, we do have information about school attendance for children attending government schools, and we are continuously working with Health and Education to improve the memorandum of understanding, to improve data sharing for both health and education, and it has improved, and this afternoon we can go into more details around that if you wish.
Yep, that'd be great.
And the system review into out-of-home care has directed us to work at a secretary level across those agencies to drive a much more strategic approach to improving data.
Great, thank you. And so on that, how many young people were enrolled in 2025 and then also for this year who are in out-of-home care?
Yeah, we won't have the numbers for 2026, but for 2025 there were 10,341 students in out-of-home care enrolled.
And what's the percentage of young people who are enrolled, or not enrolled, I should say?
I think you might need to clarify what percentage of what.
Or the percentage of young people in out-of-home care who are not enrolled.
We've got a whole lot of children that aren't of school age in the out-of-home care system.
Obviously
as well.
of school age I'm referring to.
Okay.
Yeah, so we have that data at a caseworker level, but it's difficult to get a summary of data because a lot of children go to non-government schools, and so whatever we do with the education to improve data won't answer that question. It's one of the problems we need to solve in our reform.
So do you have the data for non-government schools?
Yes, as I said, 2025, 10,341 children enrolled.
I'm asking for the percentage that are not enrolled.
Not enrolled in public schools?
Yep.
I don't know how many are enrolled in non-public schools, in non-government schools, so I can't give you a neat percentage of that. There are 13,500 kids in out-of-home care. Most of those are school age, but not all, and 10,341 are in government schools, which means there's a small number that are not eligible to go to school yet, and there's another small number that are at school in non-government schools where we don't have visibility centrally at the moment.
We might go into this a little bit more because you answered some questions last year around this, so this afternoon I might delve into this a bit more. How many children in your care have a health plan?
If I might just for a moment go back to the education piece, and that the increasing the children who are in out-of-home care and their engagement with schooling is a priority for us. We understand the absolute importance of our kids engaging in schooling to ensure that they have got everything that they need to equip them for the future. And so the Secretary's engagement is fulfilling our commitment under the System Review Recommendation 1 for the Secretaries of DCJ, Mr Tidball, of Education and Health, which is relevant to your current question, and the Cabinet Office are forming a child and family wellbeing forum, bringing the secretaries of each of those departments together, which is to ensure that our government is using all its levers to provide these children with the safety, security and futures that they deserve.
So, Minister,
sorry, back
how
to-
many children in your care have a healthcare plan?
Mr. O'Reilly
Sure.
also has that answer.
We do have a quarterly data exchange with Health, and according to Health, there are 13,437 children on the out-of-home care health pathway, which is what that means. And so that includes an initial assessment and then a periodic assessment depending on the needs of the child.
And how many of those children have the required assessment done? And that is according to information you provided last year.
Yeah.
0 to 5 must be done every 6 months, 6 to 14 years every 12 months. So how many of those are having their reviews done as required?
Yeah, I'd have to come back to you on notice to get that level of detail, but what I can advise related to that question is that we have seen an increase of 21% in the last year in children who receive their 30-day initial assessment on time, and an increase of 28.8% in the number of total primary health assessments. And reviews are stable, similar to the previous year. Okay. So there's been an improvement in performance in the out-of-healthcare teams working with Health and the way they work with our caseworkers or NGO caseworkers.
And I would also add, in relation to our obligations and commitments we've made under the Disability Royal Commission and recommendations in terms of particularly Aboriginal children in out-of-home care access to culturally safe assessment tools, and we have seen the application of Ask Track, which is a culturally safe health assessment tool for Aboriginal kids, being applied far more consistently, and we're close to completing that task as a response to the Disability Royal Commission recommendation. And I was really delighted to see it actually happening out at Broken Hill with a beautiful ATCHO that's Murray Ma that's delivering that for us out there.
They're very good organisation.
We're anticipating that by the end of March we'll have a data exchange with Health to show the number of Aboriginal children who've been through that assessment.
Great.
Perfect, thank you very much. Minister, the Child Death Review noted that of the 38 reviewable deaths that occurred, 17 were known to DCJ and 13 of those did not have a healthcare plan. Is that a concern to you?
In relation, obviously the Child Death Review team does incredibly important work, and their findings and their investigations help inform a lot of the work that we do alongside all of the oversight body reports. And obviously every child death is an absolute tragedy and is something that we want to avoid at all cost. So in terms of the child death reviews, though, as I understand, not all the children that are subject to those reviews are actually in out-of-home care. Is that accurate, or they? I might just defer to the.
Yeah.
Defer to.
I was asking about the ones that are in your care, and I asked whether or not you were concerned about the fact that.
Sorry.
The report was that 17 children known to DCJ, 13 of them did not have a healthcare plan.
Ms. McLaren-Jones, known to DCJ is a separate, is quite separate to actually being part.
Sorry, I should say
in care and part of the system.
Okay, so
known
I
to
should say
DCJ means that family. Sorry if I might complete my answer. Known to DCJ for the context of a child death review team means that either the child themselves or a sibling of that child has had a report made to the Child Protection Helpline within 3 years. I probably have to.
Minister, I'm happy to rephrase my question.
Of the child's death.
I'll rephrase my question. 13 of the children in your care, who died, did not have a current management plan, health plan. Is that a concern to you?
It is always a concern to me if there is any child in our care that doesn't have the plans that we would like them to have, whether it's a health plan, a leaving care plan. That is something that we are trying to ensure we've got greater consistency of, particularly across all of our NGO partners.
Minister, I just want to go back to questions from my colleague around children who are not with their authorised carer. And I just wanted to get a proper breakdown of how many are currently self-placing.
Sorry, Ms McLaren-Jones, are you asking how many children are currently self-placed? Is that the question?
Yeah, they're not with their authorised carer, they're self-placing.
I will have to take that on notice.
Do you know how many are listed as no placement or whereabouts recorded?
Obviously this is a cohort that we are always very concerned about, and again, we'll take that on notice.
Well, as of the 30th of June, according to supplementary questions last year, there were 239 with no placement or whereabouts recorded. 432 were self-placed. Do you know how many currently are placing with a parent or parents and not with their authorised carer?
Given the specificity of the question, I will have to take that on notice. I don't have that details in front of me right now.
As of the 30th of June last year, that figure was 298. Minister, this is budget estimates. Don't you think that these basic questions that do get asked at each estimates you would have in front of you, or someone at the table would have those answers?
Ms McLaren-Jones,
these are children in your care.
Ms McLaren-Jones, it's information that we may be able to come back to you at the end of today's session, but this is a very complex system involving 13,500 children currently in care, and
1,000 of them
innumerable
you don't know where
reports made, and we don't have every data point, but I can say this, that as a government we have ensured that we are being as transparent and open about the system that we have inherited, that we are trying to fix, more so than at any point in the past 12 years when the Coalition was in government, where you failed to talk about this system at all, let alone share any of the information publicly.
Minister, it's estimated around 300 of these young people have left their placements. Some of those are IPAs, some of them could be in what is ACAs, although you deny that they exist. Are you confident that these young people are safe when they're placing with potentially the parents that they were removed from?
I do deny ACAs exist because they don't exist. I'm just going to reiterate that for the record again for this committee, even though you would like to twist things in terms of every conspiracy theory you're reading and seeing online. In terms of concerns around children, always, I have a lot of concerns about all of the children that I am responsible for. Particularly those that are self-placing, because we want to ensure that they are safe, and we've got the caseworkers that are involved who have case management for those children. They are tasked with ensuring that they, to the best of their ability, keep a connection with that child to ensure that they are safe in the placement that they choose.
Minister, how many young people in your care that are currently should be at a cottage or at Sherwood House are self-placing?
Sorry.
How many young people?
How many from a cottage?
From Waratah Cottages or
sorry.
from Sherwood House. How many of those children in your care who should be in those cottages or at Sherwood House are currently either self-placing or placing with their parent or parents?
I'm not aware of any particularly. I can't imagine that there are any from Sherwood, but I'm happy to take that on notice just to make sure.
And again, these would be if a child runs away or leaves a cottage or an IPA, that would be deemed a critical incident and would be reported to you?
Not always.
Why not? What's the difference?
Well,
I'm sorry. If a child runs away,
it's a matter of whether or not they are considered to be at risk in the decisions that they have made, and that level of concern that we have for their safety would determine whether or not a critical risk briefs brought to me. But there are critical briefs brought to me on a daily basis. So,
Minister, a young person, 13, 14, 15, has run away from supervised, authorised care, and you don't know where they are, and you don't deem that to be a concern?
Well, in the event
because they've made that choice?
Ms McLaren-Jones, in the event that we don't know where they are, that will be a critical incident. In the event that they have left placement and returned, that does not constitute
so you're saying return back to the placement?
Correct.
Okay.
So when you're talking about whether I get a critical incident for every child that has chosen to leave their place wherever they are, their placement, it depends on the circumstances as to whether that constitutes a critical incident, and it will be driven by the degree of risk that child is facing.
Thanks. Right. Ms Abigail Boyd.
Thank you very much. Can we turn to the issues that were covered in the December 2022 Children and Young People's Committee report in relation to children who were under the care of DCJ or had records at least with DCJ, who were then being placed with an abusive parent in the family courts. We had a response from you, Minister, at the beginning of last year. There was some hope that the changes to the way that that family law, I guess, and custody disputes were working at a federal level, and the legislative changes might actually make things better. But unfortunately, my office continues to get a bunch of people coming to us with very familiar stories about how they are losing their children in custody battles to men mostly. Sometimes it's the other way around, but predominantly men who have been identified as the abusive parent by DCJ. So I guess what is your government currently doing to try and provide protection for those children in those circumstances?
Obviously, if there are concerns around a child's safety and if there are child protection issues, we would hope that they are being reported, regardless of where they are, and our department will obviously respond. In terms of the arrangements with the family court and the children's court, I believe that there's been a considerable amount of work done on that front. And Mr Tidball, this is an area that he particularly is involved in and can provide more information, no doubt, than I can on that front.
I'm grateful for Mr Tidball's work in this area, because I agree it's very much taken it seriously. I'm particularly interested in the transfer of information and the advocacy on behalf of DCJ in those cases. We see a lot more of that in other states and territories, particularly in WA, where they get directly involved to sort of put forward the evidence in relation to the abusive parent. Mr Tidball, can you give me an update on that sort of aspect of things? Has there been any improvements in information sharing and proactive work?
I fear, Ms Boyd, as I touched on this yesterday, and acknowledging that you also specifically asked about coercive control yesterday, which is a different topic, although sits beside this. We have a protocol with the family court. We have a liaison committee with the family court. We have a pathway for the statutory the court-based referrals to the child protection system, which in my most recent discussions with the Chief Justice, he says is working well, but acknowledging that you have raised, which I respect, you've raised this issue and re-raised it. If we are not hitting target and there are communication issues. This is one. There's never going to be a day where we have this working as a point in time where we have this working as it should be. If there are jagged edges with the communication, I'm very happy to, with the Minister's blessing, to take that offline and engage. And I think case examples are powerful because I have, as I've said, raised the issue with the Chief Justice, and the court is saying it's working a lot better. I hear you. If it's not, I'm very happy to again interrogate it with that jurisdiction.
Could I ask, just to be clear then, Minister, are you okay for Ms Tidball, with your blessing, if I could speak with him separately on all of the cases that have come to me?
Indeed, and
for
also
his information. So
indeed, and I was just, as Mr. Tidball was giving his answer, I was just reflecting how long you have been raising this issue on behalf of women, particularly, and in the event that you've got examples, I would also be obviously have a blessing to speak with Mr. Tidball and raise those particular examples of where it's not working. Similarly, I'm interested in understanding from the people that are raising their concerns with you, hearing directly from them as well.
Okay,
because it continues to be a frustrating intersection.
Yes.
And the last thing in the world any of us want to see are women being exposed to domestic and family violence, and then also losing their children.
That's really incredibly useful, and I'll take you up on that. I think maybe if we can meet, I would be very happy to talk you through it. Obviously, there's a lot of these women are under gag orders. A lot of them, worryingly, part of the family court order is that they're not allowed to make any Roche reports in relation to the child anymore. There's a whole, it's quite stacked against them, unfortunately. So this is the only way that we can get justice, but that would be great. All right, I will take that up with you separately. Can I come to the guardianship reform piece of work? Where is progress up to in relation to reforming the guardianship framework?
As you know, this is part of our under the Disability Royal Commission. There's a whole lot of recommendations that intersect, if you like, around supported decision making, the guardianship, restrictive practices. All of these complex issues are, and as you know, our response at the time was subject to further consideration because of their complexity, but also that it was never a no, and that's been demonstrated in what we've been doing, because we have been working closely with the Council for Intellectual Disability. There was a guardianship working group which they were a part of. That work was undertaken the first half of last year, alongside other pieces of work that's happening around supported decision making, which Council for Intellectual Disability is also involved in. So I guess there were a number of moving parts to all, in response to all of those recommendations. There are, as you would appreciate, a lot of different views across the disability community about the right approach, particularly when it comes to a senior practitioner model versus supported decision making. We are working our way through this complexity as best we can, and it's and I'm pleased to say that there's a current pilot with the trustee and guardian around supported decision making in particular.
Is there a timeline for legislation on either the supported decision-making stuff or the restrictive practices?
I'm going to be really frank with you, and not at this stage, purely because we are still working our way through a number of complex issues, and as to whether legislation change is the ultimate end, I can't say at this point as to whether that's where it will land. But I've just recently met with the Ageing and Disability Commissioner, and also with the trustee and guardian and the public trustee, the public guardian, and talking through some of the complexities of all of this. And we want to ensure that we get it right and ensure that people with disabilities have more control and choice over the decisions that they're making.
Yeah, okay. It's one of these areas that's incredibly frustrating for people. And to be fair to you, I was having these discussions with Gareth Ward when he was Disability Minister in relation to restrictive practices and saying, can we get legislation by the end of the parliamentary term? And that didn't happen. Do you think we're going to get legislation by the end of the parliamentary term?
Well, when it comes to supported decision making and guardianship, so as I said, we're still working our way through to determine whether or not legislative reform is the right approach. So there's a lot of work still to be done in deep consultation with the disability community.
Another area where I'm getting it's not statistical because it's just whoever happens to be sort of contacting my office, but we have noticed an uptick in people with disability complaining about their treatment by the police. And we've talked in the past about accessibility of police stations and things like that. What they've got in Victoria is a model of disability liaison officers in the police that have that experience where they can better serve people with a variety of disabilities, and that has helped, at least sort of anecdotally, that seems to be helping with that access to justice. Is that something that you have considered at all recommending to the police?
It's a conversation I had with the former police commissioner, yet to have with the new police commissioner, and one that is, and I know was heard and acted on by the former police commissioner as well, in terms of ensuring that the police have, as part of their training, a better understanding of people with disability and their needs in settings that are invariably acute and intense. So there's obviously more work to be done, but it's that training piece around with police that I think is going to be really important, and it's a conversation that I'll have with the police commissioner. Certainly have had it with the police minister as well, whilst appreciating the complexities of the environments that they work in as well.
Just as one example, and I think one of the privileges of working in the disability justice space is that you often sort of hear stories that you might not necessarily have understood until you hear it from that person's perspective. And without wanting to talk about the anti-protest laws and that sort of aspect, but using that as an illustration, I was contacted by a lot of people who were, they believe, very unfairly treated by police in one or more sort of rally situations because of that lack of understanding of what a person, particularly neurodivergent people, were going through in that moment. And that sort of, I'm not sure a disability liaison officer is going to fix that, but that sort of embedding in the police culture an awareness and understanding of different types of disability and how that might play out in those sorts of situations.
And I think you're spot on in terms of the need to embed awareness within the culture of our police, and I'm pleased to report to the committee that the police are now completing their first disability inclusion action plan. It's not a requirement as an agency under the Act, but they have opted to do it, as I understand. And for me, I think that's a really exciting step. It presents an opportunity, and I've heard from the workforce as well, that it provides now the space for a conversation that wasn't being had before, and ensuring that they're going to now have measurable targets as part of a inclusion action plan, so that there is that cultural shift, improved awareness, which we hope will translate to better responses.
Just in the time I've got left, I just wanted to ask you about the sort of funding models for community services across the board. So obviously I'm very focused on disability service providers, but also I know that this is equally applicable in a lot of community out of home care arrangements, services and others. There's a real frustration about funding not moving with the real costs of operation. So I know that there has been, for example, there was some increase in grant funding to cover the increase in minimum wage that was granted by the Fair Work Commission. But when it comes to rising commercial rents, when it comes to increasing costs of insurances and all the rest of it, that's not being taken into account when the sort of grant money is provided, I guess. Has there been two things? Have you collected any data on the real costs to those services of what they're dealing with? And also, have you given thought to a funding model that takes into account those unavoidable costs that these organisations are facing as they increase?
I appreciate that there are cost of living pressures applying to everyone, individuals and organisations, but I can assure this committee that the programs which I am responsible for in the early intervention space, which was targeted early intervention and family and community supports, which has now been rolled into the community and family support program, otherwise known as CAFS, that over the time that we've been in government, there's been I think more than a 20% increase to the funding of that program, and that program's just been recommissioned as of 1 January this year.
Is that per service or for services as a whole, that increase?
That's over the entire program. And I think there's about over 400 services as part of that program.
Yeah.
And we're also investing in early intervention, the intensive family support, family preservation programs as well. So there's a lot of early intervention support being rolled out across the state based on need, and the organisations are doing incredible work across the state, and there are occasions when it's been raised with me, but we work through any issues.
So from a data collection perspective then, do you keep data as to how many services are closing and why, what their sort of real kind of world costs are increasing over year on year? Is there any research done by the department on those sorts of issues to identify early on where the pressure points are? Make sure we don't have services closing.
Well, I can assure you that if there's any service that we have a contract with, we work closely with them if they face financial pressures that might lead to any closure. That's not something that we see, given that they've got an ongoing contract from us, and that we work through those issues where it's possible. The only service that I'm aware of that closed in the last during the last commission program was a decision made by the committee and their board not to continue the service itself. It wasn't based on funding.
Do you collect data on sort of how much rent they're paying or what their insurance is, things like that? Is that as part of their contract? Do they tell you?
Well, the services provide their budgets to us each year, so we've got visibility on that. And the other important thing, like around the community and family support massive program that we've just recommissioned, is that that is now benefiting from our secure jobs and funding certainty commitment,
Yeah.
where that program is now not just 5 years, it's a 5.5-year contract to give organisations that long-term certainty over funding,
And
which
does
is
that
what they were
funding
calling for.
Go up every year based on the real costs?
There's a CPI increase to the
So
to the
CPI,
program
So
every year.
I guess
yes.
just to sort of close that circle then, so if that data is coming in from each of those services, that could be a very interesting bit of data to work out exactly where the costs are escalating over time. Is that the sort of data that you can easily provide? Are you able to give some sort of data on what those increasing costs look like for services across the state?
I'm not sure if that's possible. Ms.
I
Campbell
think
might
it's
be able to
different in different
respond to that.
programs. So if we looked at the out-of-home care program, what we've just now standardised is the income and expenditure. So it's actually a lot more transparent. So we'll have better data going forward.
So could you do it per program that you have it for? Could you
I
provide
need to take that on notice and come back to you. Yeah.
Thank you.
And I might just correct something that I
Yeah.
said in terms of CPI being applied to the contracts. It's actually the government indexation rate,
Okay.
and that's often higher than the CPI.
Thank you. Thanks, Chair.
Okay, thank you.
7
Just in the
seconds.
remaining one. Actually, in the remaining 1 minute, you wanted to update the committee earlier on some matters. If you want to do that now, then that's fine.
Thank you, Chair. I would appreciate that opportunity. So, previously, Ms. McLaren-Jones listed some properties and waived some photographs before the committee that then weren't tabled as evidence, but listed those property names, and I wanted to report to the committee about the status of those properties. I'm not going to use their names for reasons that will become apparent. Location 1, no HCEA children. Location 2, no HCEA children. Location 3, no HCEA children. Location 4, no HCEA children. Location 5, no HCEA children, was last used in September and a child was placed in an adjacent apartment. Location 6, one child in an adjacent apartment, and DCJ is now doing a risk assessment because the location has been identified as part of these proceedings. And if we need to remove that child because that risk assessment determines that is in their best interests, we now have a young child whose impacts on their life is going to be significant. I want to be just really clear that there are no children in hotel rooms, in motel rooms. Every child in HCEAs are in home-like apartments, like many families in Sydney live in, and they are supervised and supported by accredited providers, which means that they comply with the New South Wales Child Safe Standards for Permanent Care. That is not what ACAs were. That is why ACAs are banned from our system now.
Minister,
Thank you.
Thank you.
Thank
Minister,
you.
just following on from that, so there are children in your care that are in hotel, motels and caravan parks. You've just said that they're not in the high-cost placement. What type of placement is it?
Again, I feel like I've fallen through the looking glass. You have just completely misrepresented everything I just said.
No,
and you seem
Minister-
to have missed the point that the evidence, the contribution and the questions that you made have now potentially placed a child at risk. You
Minister,
seem
I'm
to
just
have-
asking you to clarify what type of placement is it? They're not. You just said they're not HCEA. What type of placement are they?
It is an HCEA.
It is.
And there are no children in a motel room. There are no children in a hotel room. There are children in HCEAs with the support of accredited, which means, by its very nature, the HCEA program is an accredited provider, which means that they're responsible for ensuring their services are delivered in accordance with the Child Safe Standards for Permanent
I understand
Care.
that, Minister. I'm just
That
trying
is
to
not
clarify.
an ACA. It is not a child in a motel room. It is not a child in a hotel room. These are children being supported in home-like environments
Minister,
with accredited providers.
Minister, I'm trying to clarify. So you've just said there is a young person that may need to be moved. You're also trying to say that there are no children in hotel, motels and caravan parks. And yet you've just said there potentially could be a young person that needs to be moved. So I'm trying to find out, clearly there is a child in one of those types of accommodations. What type of, do you classify that as high cost, or is it another type of placement? I'm just trying to get an understanding, because you've clarified that yes, there are children in that type of accommodation.
So I'm assuming, Ms. McLaren-Jones, that you travel, get out of Sydney a little bit sometimes, and often there are motels that have apartments as part of their whole service provision. What we have said very clearly, and there's been no change in any of the evidence given today, that there are no children in a motel room, in a hotel room. There are some children in HCEAs who are with accredited providers, who are in serviced apartments in home-like settings where they have multiple rooms, laundry facilities, kitchen facilities. It's not a labour hire worker 10 doors down from a child that's sitting in a motel room and a hotel room by themselves, a situation where there were hundreds and hundreds under your
Ms. Dean
watch.
said earlier there are children in cabins. That clearly is a caravan park, and I think you're trying to play with words. The fact is that there are young people in your care in that type of accommodation.
There are children.
And you lied to the people of New South Wales in saying that no child would be in a caravan park, motel or hotel.
Yes.
And yet you're saying they are.
That is a very serious accusation to make, and I'd ask Ms McLaren-Jones to withdraw that statement.
Well, she did. She
I'd take
misled.
No, I ask you to withdraw that statement. It is offensive, and it's a very serious allegation. You're basically accusing the Minister of perjuring yourself.
No, I'm
it's
saying
a
it was
very
misleading.
serious allegation to make, and
She's
I'd ask you to withdraw
misleading.
it. I'd ask you to withdraw it.
No.
Okay.
I'm happy to move on.
Question. So, look, there was an allegation that the Minister has lied. That is a serious
very
allegation.
serious allegation to make. Very
perhaps
serious.
the word, perhaps you
Mislead.
want to...
I'll say mislead.
All right. So on your version of definitions, evidence, you say the Minister
has
is
misled.
misleading. And I think Hansard can reflect very clearly the evidence that's been given, and people will be able to make their own choices. You have the option
Chair.
to withdraw, because that is the point of order being made. I'm not going to order that somebody withdraw, but I am going to say the point of order is a very valid point of order.
I'm happy to move on to another line of questioning.
Chair, just on a further point of order, can I just say that the statements that have just been placed on the record, the Minister ought be given the opportunity to respond
I do
to those.
agree.
They were very serious
Yeah,
statements.
no, I do agree, and I think that is a valid point of order, and I would uphold that point of order because we have passed the resolution of procedural fairness. It is a significant allegation to say that somebody is misleading or is lying. I accept that you're now saying it's not lying, that it is more misleading, and I do think the Minister deserves the opportunity to respond to that particular allegation again.
Yeah.
Thank you, Chair. I obviously strongly refute the allegation that I've misrepresented this committee at any point in time, and I might refer the committee to previous evidence that I have given on this exact point, particularly in relation to our banning of ACAs. When we announced that, I made it very clear that there may be on occasion a time when a child in an emergency may need to be placed in a motel itself, and you know that was on the record, and I copped it. I copped criticism from the Guardian because I was very clear that if one of our caseworkers in the middle of the night has to make the awful decision to bring a child into care and there is literally no other option, there can be occasions when that may occur. And I was very open and honest about that before. But what I'm very clear on, and I have read onto the record, that the photographs that were waved around earlier today are there's based
I
on
think the minister
based on
has-
conspiracies that are swirling on
Point
social
of order,
media.
I think the minister
that
has clarified.
suggests-
I've got limited time to ask questions.
Okay.
To
yeah,
the point
I
of
think,
order, the minister can answer the question.
Yeah,
as she
no, I
sees
think
fit.
I think
She's
that
being
look, I
relevant.
think the Hansard is going to reflect the proceedings in the clearest possible way. Let's move on.
Thank you. Just following on from questions from my colleague in relation to the community and family support, I just wanted to know of any of the unsuccessful organisations that obviously didn't get contracts, were any of them provided additional funding or had their contracts extended beyond the 31st of December last year?
So in the recommissioning of the community and family supports, which is now the combination of targeted early intervention and family and community supports, 96% of those providers were recontracted. The very small percentage of organisations who weren't, there is a transition towards exit that's been in place, and as part of that transition, different plans have been put into place for some organisations.
And was that available for all unsuccessful applicants?
It was based on depending on the need, there was different conversations had with different providers to assist them.
And who made that decision?
The department.
And what was the criteria that they looked at for awarding extended contracts to one organisation versus another?
Based on the information that was provided to them to assist them to transition out of the program.
And were any other types of contracts provided? Or were they all just extensions for a short period of time as the other two closed up?
I don't think there were any other contracts provided as part of the transition.
Okay. Just in relation to family preservation, I'm interested to know how many providers have been awarded contracts under the new recommission of family preservation, and how does that compare to the previous numbers?
That is currently still being finalised in terms of the recommissioning process. It is a program that we are very keen to see in place and having the impact that we hope it will, particularly in terms of the increased investment in ACOs of 40% of the program, which is something that the sector has been asking for and has also welcomed.
So the contracts haven't, like, the providers haven't been advised? Are you saying it's still in work in progress, or it has been finalised?
I might pass to Mr O'Reilly. Obviously, the recommissioning of a program is something that the department manages, and I'll pass to Mr O'Reilly for some detail on that one.
The commissioning process is nearly complete, but not quite. And so where we are currently is we have been through a rigorous assessment process across all locations, and we have contacted preferred recommended providers for each location, and we're in the process of negotiating contracts with those. Once those contract negotiations are completed and contracts are executed, only then will we know how many and which providers have been successful. Some of them may choose not to take up the offer, which means we have to make some changes in that location. So it would be misleading to tell you the number that we're negotiating with now, and it would be quite disruptive to the contract negotiation process and most likely in breach of our probity standards. So we anticipate in the next few weeks we'll have a clear picture.
And when you said you went out to tender, did those offers go to all existing providers?
It was an open tender for anyone who met the criteria to apply.
Yep. Of those that have been successful, how many have restoration experience?
I can't tell you that because they're not successful yet. They have received an offer which is currently being negotiated, and after that we'll have a very clear picture and we can provide the committee with information about who has been provided a contract.
Could you then provide how many of those have restoration experience?
We can possibly, but it's important to note with family preservation, this is work that happens before out-of-home care. It's not the same as restoration. It's different function. So we might be able to ask that question. Not sure what the answer is going to be.
Okay.
Yeah, 'cause it's a different function.
And how many of the providers that are that you're obviously looking at with contracts, how many of them do you consider their staff numbers and whether or not they actually have the capacity and the staff trained to carry out the contracts?
Yeah, we need to consider their capacity to deliver what they're saying they can deliver, absolutely, which is about staff, governance, financial capability, footprint, all those considerations are important.
Minister, how much has been invested in the family preservation?
In the recontracting, in the new
The
model
overall budget?
Mr. O'Reilly, how much is the program?
It's $180 million per year.
Beautiful.
And is that the, how does that compare with previous years?
Oh, indexation, so it's a little bit less, but yeah.
About the same?
Yeah.
And if I might add on the, not only are we with the recommissioning ensuring that we've got 40% of the contracts going to ACOs, for the first time what we are ensuring is that the family preservation packages, which provide intensive support to families to try and prevent children coming into care, which is a real goal of our government, that we're going to have, the packages are going to be based on need. And in terms of your question around capability and capacity, part of the one of the criteria in the recommissioning was a minimum contract value to ensure that our providers have the quality of service delivery that comes with having a certain volume of packages. So there's it's been a very definitive approach in order to try and get the outcomes that we want, particularly when it comes to keeping children safely with their families, and particularly Aboriginal families and children. So the existing contracts cease on the 30th of June, with the new ones commencing obviously 1 July. Is that correct? Has any assessment been done around the transition of families from an old provider to a new provider?
Yes. The department's been working with the Peaks and our district colleagues. My team has been working with the Peaks and our district colleagues in the department to develop transition planning for each location.
Minister, how much has been allocated out of the $180 million per year to ACOs? You said it was 40%.
40%, which is a significant increase and a significant investment in our ACOs, and it's, we are hoping that it has the impact that we want it to see, to keep Aboriginal children safely with their families.
Do you know the figure? How much is being invested in ACOs as part of the family?
Yes, 40% of 180 million is approximately 70 million. That is the goal.
And that's over a 5-year period?
That's
obviously.
per year.
That's per year.
And over a 5-year contract?
Yes, per year times 5, that's right.
And how much of that is new investment? Or new money?
It's the same budget. Yeah.
Minister, you've talked about in your social media posts that you're making an historic investment, but the fact is there's no new money.
Ms McLaren-Jones, we are making a historic investment in out-of-home care and across the child protection
Your
sector.
post is specific to family preservation.
We are investing in ACOs like never before, Ms McLaren-Jones, and it has been welcomed by the sector. We are also investing into all of our programs. The $1.2 billion child protection package in the last year's budget makes it very clear that we are investing in this sector and we are investing in better outcomes for children.
Have you made a budget bid for additional money for early intervention and family preservation, to be able to actually put new money in?
Ms McLaren-Jones, we are just, as the evidence has just been given by Mr O'Reilly to the committee, we are just in the process of recommissioning and finalising the recommissioning of the current program. So that is where we are at. We are going to be seeing significant investment in additional support for children across the state in the 0 to 8 cohort and the Thriving Kids program. I believe that is also going to make a significant difference to young children and families across the state.
Will that be new money?
Yes, Ms McLaren-Jones.
Minister, in the Family Preservation Funding Approach paper, the government committed that, and I quote, DCJ will commission a specialist cold service to support practitioners delivering families together to access cultural expertise and advice for working with cold families. Could you update the committee on how that is going?
Sorry, Ms McLaren-Jones, I missed the first element
it's part of the
that.
Family Preservation Funding Approach paper, and it says DCJ will commission a specialist cold service to support practitioners delivering families together. I'm just interested to get an update on that.
Mr O'Reilly is in the weeds on the Family Preservation recommissioning. I'm going to defer to him again.
To some extent, I'm in the weeds. Yes, that's part of the work of the program team, which is underway at the moment.
Okay. Another one, just in relation to the Kids Early Years Network, in November 23 budget estimates, you advised that a full evaluation of the Kids Early Years Network would be delivered in 2025. Has that evaluation been completed?
I'll have to take that on notice.
Okay.
I don't think it has, Ms McLaren-Jones, but I think we've got a draft at the moment. So the Minister would not have seen that because I haven't seen it.
Minister, why it was due to you last year? Why hadn't you followed it up?
Ms McLaren-Jones, I've met with the team at Keys and I've seen the really important work that they do. Obviously, an evaluation of a program is important, and we are awaiting the results of that evaluation. As I keep saying to this committee, we are ensuring that we are evaluating programs so that we can invest in evidence-based programs that work, and so that's why we are awaiting the evaluation of the Keys program. And sometimes these things take a little bit longer because there are significant complexities involved in the type of work that they do.
Sorry, so the evaluation hasn't been completed, or you're waiting for it to be given to you, or
I'm advised that we're waiting for some more data from the organisation.
And when does their funding run out?
I need to take that on notice.
Okay. Minister, just in relation to carers, do you have a breakdown of the number of carers that are under DCJ that cover home-based care, short-term and long-term? Happy for you to take that on notice.
I'm just pleased that you're asking about carers, because it is a critical pillar of our out-of-home care strategy that we just launched to ensure that carers are going to be valued and have the respect that they deserve. And obviously in the last budget they benefited from a significant investment which saw that their allowance has increased, the base DCJ allowance has increased by 20% for the first time in 20 years.
I'm happy for you to take it on notice.
In terms of... well, I'll take it on notice.
Thank you. Minister, how many carers exited the system in the last financial year? And how many have been recruited by DCJ? I think somebody's really going to be handing me those figures in just a moment. But what I can say is that the recruitment that's been undertaken by DCJ has meant that there has been an increase in the number of authorised carer households by DCJ. The number of authorised carer households that are in the case managed by NGOs has dropped. So because of the work that we've been doing, the department has been able to increase our authorised carer households. Unfortunately, that's not been the same across the sector. But in terms of emergency carer recruitment by DCJ, that figure is at 272. Authorised carer households is currently 9,975. Now, those emergency foster carers that we recruited have supported, I think, more than 800 children, perhaps more, and ensured that they didn't go into other less suitable arrangements. My time's expired.
Thank you. Minister, can I just take you back to the OMBO report last month, the No Capacity to Allocate report? One of the In the report, it states, there's a part of the report that states, our staff survey results confirm anecdotal evidence suggesting that the performance targets create a perverse incentive for some staff to preference the allocation of certain ROSH reports or avoid allocation in such a way as to increase the count of children seen. We asked those staff who had a direct role in the allocation about their views of the impact of the targets. This part's the relevant part. Nearly half said the targets influenced some staff to allocate in a way that would increase the children seen statistics instead of allocating to those children and young people assessed to be most at risk. This includes, for example, prefacing reports about large families where more children can be seen simultaneously. Are you able, or is there any information on what percentage of these large families were Aboriginal families?
Sorry, Chair, I don't have that that detail for you today, but I have heard I've heard similar things speaking to caseworkers, particularly when I first became minister. I don't think those practices are continuing, but they are certainly something that we want to address in our new policy that will be rolled out in response to and taking into account of a lot of the recommendations that the Ombudsman has made.
Okay. And if there was evidence of those practices still happening, you would want to know about that?
Correct. We want to ensure that we are seeing the right kids at the right time. It's of critical importance that the children that need to be seen are seen. And if that was actually still happening, I think the current data where the number of children being seen is dropping, I think if that practice is still happening, it's certainly not making any difference in terms of the work that's being done to see children.
It's been said to me that there are districts that do and don't have dedicated teams to respond to the reports of children, the ROSH reports. Is that the case, or do all the districts have capacity, the dedicated teams?
All districts have got capacity, but what we know, and it was clear in the Ombudsman's report too, is that the consistency of practice across the state is a concern. And so Ms Dean has been doing a lot of work in terms of lifting capability amongst our caseworkers, but also heading towards an organisational change to ensure that there are clear lines of accountability and responsibility when it comes to statutory responses and supporting children in care. This is a key part of our reform as well, our out of home care reform that we announced last week, that the transparency and accountability not only applies to our outsourced providers, it applies to the work that we are doing ourselves.
Thank you. In relation to the inquiry into intensive therapeutic care and the report that was tabled in December, and I know you said that you're now undertaking the first evaluation. Is there, will you be, in relation to that, are you engaging very early with the Aboriginal peaks in relation to any reform and that evaluation?
It is imperative that any steps we take on any front and design of any policy involves our Aboriginal partners, particularly when it comes to the intensive therapeutic care evaluation. Of course, we'll be listening to the voices of kids, voices of Aboriginal sector, families, communities. It's all going to, all of that is important to getting the best outcome we can for a redesigned system.
And in the recent announcement that you made and the strategy that you have tabled, you talk about, providing transparency around funding and providing that comparative to how much money is going to each particular aspect of the provision of care and therefore the children. What do you say about how that comparative analysis is unuseful when you're looking at, we're not comparing apples to apples. Like, there's different types of therapeutic, intensive therapeutic care that is provided, and obviously some of the administrative costs around the particular provision for some therapeutic intensive care would be higher and different. Do you accept that, and is that something that will be properly accommodated going forward, that some of these out-of-home care providers won't be left going, oh my gosh, we look like we're getting more money for this, whereas this is what's needed for all these reasons? Is that going to be possible going forward?
Well, a report that I haven't mentioned yet today that's also a significant element in the work that we're doing in our reform is the IPART report, which has given us the building blocks for costings for the delivery of certain services. But what we do know is that the permanency support program has failed, and there is a clear case for change. When we've got $1 billion now going to our outsourced providers, but the outcomes and the goals of that program have not been met in terms of restoration rates down, adoption and guardianship. All of those rates are down. Those permanency goals have not been achieved, despite the rising public funds going to outsourced providers. So yes, we've got a significant amount of work ahead of us, but the goal is to increase that accountability and transparency in terms of the provision of public funds for a public purpose, which is to keep kids safe.
But so there will be, I suppose what I'm trying to understand, and I know there's people out there that want to know that, because on a balance sheet, it may be apparent that there's a spike in a particular aspect of money, public money, going into something particularly where you're looking at intensive therapeutic provision of care, that it may look larger, but there is a very good, important reason. For example, we're literally keeping children out of the criminal justice system, or, those sort of genuine issues that are happening on the ground with some of these care provision of care.
Understood that these organisations play important roles in their communities and can be providing lots of different services, but we contract to them for a particular purpose, which is to support children in out-of-home care. That is the contract that we have with these providers. It is our expectation that the public money that is being spent, that is being paid to these outsourced providers, is spent on exactly that purpose. What we have seen and uncovered through looking at what our outsourced providers actually do with funds that DCJ pays to them has been eye-opening, to say the least. As you know, I've been quite vocal in some of
Indeed,
some of
you
that
have,
as well.
and
I appreciate that, the backup on that, because, an example is an organisation charging 7 times the amount of their organisational funds, which is I should say that they took 7 times the amount that their actual organisational expenses were. And just putting our funds into a different bank account and calling them non-DCJ funds does not make them less accountable to the public about what they are being spent on. So, and when we've seen other providers with their lease arrangements on their cars, where they have charged DCJ 120% of the value of that lease, but we still don't own the car at the end, then the car is sold and it's a windfall profit to that provider. We, in the future system and in the transition, which starts mid next year, accountability and transparency are non-negotiable when it comes to the delivery of services to vulnerable children. So we have got a zero tolerance on any financial mismanagement. Every taxpayer dollar that's being spent in the system to support vulnerable kids ought to be going to their care, and that's just not what we've been seeing consistently across the sector. Saying that, there are an enormous number of workers who are dedicated and doing a lot of good work in the sector, in the department, but the system is often frustrating them in their goals as well.
Thank you. Back in February, a couple of years ago now, 2024, that's when you announced the new Restoration Task Force and to oversee the efforts to return as many Aboriginal children to their families from the child protection system as is safe. And you've talked about that a little bit, but I'm just curious now, given in 24-25, only 100, I think this number's correct, only 131 Aboriginal children and young people exited the out-of-home care system through restoration, and that was a decrease of 17.6% from the year before. So I'm just curious about what your statement now is. Do you say that DCJ is improving restoration practices, notwithstanding those rates not reflecting an improvement?
Chair, when it comes to restoration, we have got a lot of work to do. And that's why it's a key element of our of the reform that we've announced just last week. It's complex work, but it is critical, and we have to do better. And that's one of the permanency outcomes that has not proved itself as part of the last contract that was. So since I made a commitment to having a restoration task force, we have been working in good faith, trying to work out a way that we could stand up a particular proposal. Unfortunately, that has not been possible, and I've now tasked the department with designing a restoration task force that we can that will actually start seeing these figures turn around.
So what would you say if somebody I ask now, what community-led restoration work is occurring within ACOs now that you're aware of that is something that should be reinforced, if that is the case?
Well, the permanency support program, which has demonstrably failed, there is funding as part of that contract for restoration work to be undertaken.
So if it's not working and we've identified that, what do we, I think that's the point, as of today and tomorrow, you know, where is the restoration work, where is it happening or is it not happening?
Well, it seems there's not nearly enough happening. That's very apparent. And I know that there's work being done within the department. There's certain
so how does that
parts of it.
How does the internal work, and it may be the case, how is the internal work in terms of working in terms of that commitment for an Aboriginal-led restoration initiative?
What we have within the department is an amazing workforce of.
And I do know this, just so you know.
No, but of many very strong Aboriginal people. They are very brave to work within the department, and we have got a strength within the department that we want to harness. The state Aboriginal reference group recently marked its 40th year, and that strength within our department is something that we are going to be working with to help develop a way forward. And this is all at the same time as another important element of our new out-of-home care strategy is the retention of matters before the court with the department. That will give us an opportunity at a critical time to have intensive work done to determine whether it's possible for restoration to occur prior to permanent orders being made. So there's a lot of different parts of this that we hope will lead to greater restoration rates, and there are already programs that we fund that are undertaking restoration work in the state, and including with Aboriginal families. And I visited one recently in Newcastle, being led by Uniting. It's the New Pin service, and met with an amazing Aboriginal mum who had her children restored to her, courtesy of the incredible work that she had done as part of that program to get herself in a position to have her children restored.
What about the restoration team within the Office of the Director of Legal Services? Is that something that you have oversight of? And that, I think the team is headed up by Tracy Thomas. Is it?
Tracy Thomas.
Yeah, is that something you have oversight? That particular team?
I have oversight. That is if you're happy for me to
please.
answer. That is a child law team.
Yeah.
A child law team, not specifically looking at, not looking at restoration, but looking at child law matters.
Yes.
Because is it not, that's where the work is kind of quite inextricably linked? Is that the case, or?
I think the difference, it runs cases, so it has a,
Right.
and I'm happy to be
Yes,
corrected by Mr.
if I
O'Reilly,
could,
but
the team in child law that you're referring to has expertise in running child matters in the Children's Court and expertise in restoration matters as well. So we're working out how can we partner them with casework teams in the department as we change our operational structure and as we work to develop a restoration strategy, which is one of the work streams announced last Friday. But all those pieces of work need to come together for an integrated strategy. Part of it is about the way that our legal team works with our casework teams. Part of it is about the way that we contract restoration services in a new funded services model into the future, which overcomes the barriers that PSP structurally has to achieve restoration.
Thank you. And I will talk more about the PSP kind of replacement, how it looks in real life. Obviously, there's the strategy, but we can come to that. Can I just ask about so going back to the joint protocol to reduce the contact of children in residential care with the criminal justice system, and this was developed a decade ago and updated in 2019, and that protocol, as I understand it, hasn't been reviewed since 2019. And I'm just wondering where you see, Minister, that work in terms of your priorities, including, what monitoring of that joint protocol to reduce the contact of young people in residential care with the criminal justice system, or whether you have new work that's kind of overtaken that.
Chair, the joint protocol, I'm aware that there needed to be a bit of a revitalisation of that and the work, and part of that is ensuring that our providers understand their responsibilities, which under an outsourced system is challenging, and so it's clearly going to form part of our evaluation of the intensive therapeutic care program itself. But we've got a strong commitment to developing and improving the collaborative models for diverting children away from the criminal justice system. And so that work is ongoing.
Can I ask you, Minister, that when you are in well, I won't ask you about cabinet deliberations, but because I know where that goes. Minister, your government has, in really clear to everyone, had a program, a law and order program that has seen more First Nations kids behind bars in New South Wales than ever before. the rate of escalation has been off the scale, and again, like the increased rate, like never before. These kids are in remand, often not convicted. Are you making clear to your colleagues that this work is very controversial in terms of your ministerial portfolio in relation to kids in out-of-home care?
Chair, what we are seeing just reinforces for me the importance of the work that we are doing to strengthen our system and ensure that children are staying safely in our system. Part of that is the ensuring the joint protocol is working as it should, ensuring that we've got the therapeutic supports in place for children in the intensive therapeutic care system, ensuring that the foster carers have got the supports that they need to care for the kids in their care. That is my responsibility as Minister, and I take it incredibly seriously. So in terms of kids and their intersections with the criminal justice system, I've got a role to play to ensure that we are keeping, to the best of our ability, the kids in the state's care safe.
I'll keep going. Can I just ask then, in terms of that joint protocol, what is your anticipation around that? Are you going to update that, review that? Will there be, or should people think that won't, or that work won't continue?
Well, as I understand, the joint protocol is supported by a steering committee, which is focused on its impactful implementation. So that work is ongoing. But there's more work to do. Like everywhere we are looking and the work that we are doing, there's more work to be done.
And so with the so there's an escalation process. There's the escalation pathway for that joint protocol, and that was, as I understand it, published in September 2024, more recently. Is there information on how many times a specific issue was escalated to an executive district director? Like, is that happening? Are you seeing that work happen?
I would have to...
Okay, thank you. And if you can also take on notice, I am interested in what ongoing monitoring or oversight there is of the reports made to directors and senior managers, and whether this, I suppose the thing is as well, Minister, is this is something for you to have view of, because this is where the escalation of these matters takes place.
If I may just supplement the Minister's evidence, just making the point that the steering committee does have an interagency oversight through legal aid, the ALS service providers, the Office of the OCG, and the Advocate for Children and Young People. So I can come back with more detail, but
I've got a list of questions that I can give you to take on notice. There's a genuine need to understand from constituents out there. They want to know what's happening and is this still being effective, because there's a lot of people trying their hardest, following this protocol, doing this work and wondering, is it being properly, is it effective? Is the Minister aware of it? Is there more that can be done on this side of the work? Okay, I'll hand over to you for 2 minutes. Thank you.
Thank you very much. I just wanted to touch base on remaining time regarding the DAPs. Now, I understand each LGA must submit a DAP at least every 4 years. Are they provided to you, Minister?
I don't know if they're provided to me specifically. Certainly they'd be provided to, I assume they'll be provided to the department, but we are doing a lot of work across all of our agencies to ensure that our DAPs are all lining up for development and finalisation by the middle of this year, flowing on from our issuing of the Disability Inclusion Plan late last year.
Okay. Are you aware that there are a number, potentially close to 20 LGAs that are currently operating under expired DAPs?
It doesn't surprise me. There's lots of different priorities for different councils, and we will, we can get in touch with them. And I think the department does what it can with councils. They can't force their hand.
But under the legislation that all agencies and the LGAs are required to have DAPs, you're the minister responsible, so I'm interested to know what action you've taken. Obviously you haven't been alerted to this, but what responsibility you take for ensuring that agencies and LGAs do implement their DAPs as required.
I'm just advised that the number of local councils, I'm told, is 119 of 128 have a current DAP as at December last year. And I can update the committee and take on notice the work that's being done to ensure that those outdated DAPs are replaced in time with current DAPs.
And are you confident all agencies, all government agencies have current DAPs as well?
I'd have to take that on notice. Courtesy of a decision that I made, that we were to introduce our disability inclusion plan and we wanted the DAPs to flow from that. There may have been some time where where agencies were intending to produce their DAPs a bit earlier, and then I've asked them to take into consideration the statewide plan for their own plans. So there may be agencies that have DAPs that aren't current, but they are all working on making sure that they are all going to be ready for mid this year, with a view to actually aligning them all. That's what we were trying to overcome, was that all the agencies had their DAPs dropping at different times, and it wasn't also aligning with our disability inclusion plan. So by creating a bit of a system where the disability inclusion plan drops and our priorities are clear, then that feeds into the work being done by agencies to produce their DAPs.
And just to add, we've got advice that all agencies are on track to complete that.
Thank you. That saves the question in the afternoon. Thank you.
Okay, we're in government time. No questions? Okay, well, on that basis, thank you very much, Minister, for attending this hearing. We're finished with your questioning. I see you would like to say something.
Thank you, Chair. And it was just, I wanted to recognise the extraordinary work that's done by the dedicated people that have come today, but also wondered whether or not, with the committee's indulgence, whether or not Ms Ward and Mr Smith might be able to, if there are any questions for them specifically in the afternoon, that they might come earlier in the day, so that they might be able to leave a bit earlier and continue with the important roles that they have. And I apologise for the rest.
We usually have that conversation.
Not diminishing the importance of the roles of anyone at this table.
No, we totally hear you. We normally have a quick chat, and we will, as soon as we're back.
And you're fortunate because there's no other inquiries going where crossbench have to run between two. That's where the challenge is usually.
So we should be able to deal with you swiftly and let you go. But look, with the committee, thank you, Minister, really for attending this hearing. We've finished with you and your questioning for now, and the committee will now break for lunch, and we will return at 2 p.m. for further questioning. Thank you all. thank you all and welcome back. And we will now begin again with questions from the opposition. Thank you.
Thank you. Thank you very much. I might actually just start with just a broad question around insurance premiums, and I'm sure you'd be aware that some in the child protection sector are concerned around increase in insurance premiums, been ongoing for a number of years. Just want to get a bit of a broader update where that is tracking, and have we landed anything with the Commonwealth, or what supports are available for some of those NGOs and
So we're
providers?
Yes, we run a scheme. It's not a
Sorry,
Commonwealth
Mr. Dewar, we might
scheme.
need to move the microphone forward. Just
I
for
do
Hansard.
apologise. And what I might do is
Actually,
hand
are they on?
to Ms Campbell. Can you hear me?
Yep.
To update us on where we're at with the scheme.
Okay, so I think Ms McLaren-Jones, you're talking about the special liability insurance scheme, correct? Okay. So the current status of that, which is delivered through iCare in New South Wales, is as of Friday the 27th of February 2026, iCare has issued 43 renewal quotes to service providers currently on this scheme, 7 of which have been accepted to date. No affordability concerns have been raised as yet. That's not to say that won't happen. And as of the 12th of February 2026, there are 66 providers participating in the scheme, including 37 out-of-home care providers, 17 youth homelessness services and 11 that cross both those programs. And a total of 7 claims have been notified to iCare during the scheme's setup. So the costs of the premiums, which has been an issue, because in the first time we started in this particular scheme, NGOs had to pay 15 months. This year it's 12 months, and it looks like they've gone down a little bit, but we won't know until we actually get the quotes that come back from iCare.
And you said that obviously where it has been an increase, you haven't received any issues raised as yet, but you've foreshadowed there could be. What is planned for the support? And basically, because some of these organisations, their premiums are extremely high because of the nature of the work and the complexities they're dealing with, and the last we need is them to close. So what is in place, or what can be put in place, or what's being considered?
We look at it on a case by case,
Yep.
so that's always been a concern from way back in time with this particular scheme once they couldn't get access to the private market. Yep. There are a number of providers though that are still in schemes, mostly overseas.
Yep.
But certainly we'd look at it on a case by case basis, and often there's multiple pressures on various NGOs. It might not just be around the insurance, it could be workers' comp and a range of things. So I had a meeting, I think it was last preliminary meeting with NCOS and Aqua with one particular provider, so we're having a look at that at the moment.
Yep, perfect. Thank you very much. I might move to a couple of questions for Ms Ward. Just in relation to the previous audit by the OCG 23-24 around working with children checks and organisations, I think it reported 87% of organisations audited were non-compliant. I just wanted to unpick that a little bit more. Were the majority because they were still waiting for them to be approved and they're preliminary, or were there other broader systemic problems?
So in relation to the non-compliance, are you meaning organisations not verifying?
Yes.
Yes.
Yeah.
So that's right. So that's exactly what that report found, was the 85%. That, I think, at the time was to do with an educational piece that needed to happen. And we're actually currently still working on that. So the government announced last year an additional $5.5 million for the OCG to work on its compliance and investigation activities. Part of that included the internal review team, but a portion of it we are using to increase the knowledge, firstly, but enforcement and compliance for the verification rates for agencies for the checks. We've done that through media campaigns lately, but what we are going to do is a little bit more targeted work in terms of enforcement.
Okay. And so there's a further review that's being conducted at the moment. I think that feedback closed this month.
Exactly. So that's.
And what are you looking to find in that?
So that is in relation to the Working with Children Check Amendment Act.
Yep.
The Working with Children Check Act is due for renewal, and that closed on Friday. We got an overwhelming amount of submissions, actually, 2,000 from our Have You Say website, 78 guided submissions, and consultations have been happening across New South Wales. We expect, I dare say, the New South Wales public will probably fall in line with everybody should have a Working with Children check. But what we do hope is to get some of that more nuanced information about what is child-related work and what does the New South Wales community expect. Is it everybody working with a child? Is it because the Act at the moment has those carve-out provisions, which does create confusion, and we recognise that. And it's something that I'm not a fan of exemptions within a piece of legislation because it doesn't provide that clarity.
And obviously there's been some structural changes, particularly around obviously not having the NCAT appeal. Could you just outline how your office is operating and the silos of someone making a working with children check application, and then should they wish to have that review? And this is more, I suppose, to ensure that clarity out there that there is that silo.
Yeah, absolutely. So the Working with Children check team is under a director. The internal review team is under my Deputy Children's Guardian that's just been appointed, the Aboriginal identified position. And they are separate teams and on different systems too, I should add. So the integration between the two really is in terms of risk assessments, processes being the same, of course, so that people go through the same process. But the actual decision making and layers of decision making are different to that of the Working with Children check team. So if a review goes through, an application's made, it goes through a much senior officer for the initial review, and then up to the Deputy Children's Guardian for final decision.
Okay. In relation to the funding, so the Working with Children checks fee increased. How much was brought in over a 12-month period or estimated to be brought in?
I don't know that I had one moment. I've got the numbers, but let me just see if I've got the actual breakdown of the figures. That's my budget. Might have to take that question on notice. I have the actual figures, but not the monetary amount.
Okay. What's the actual figure?
So for paid applications that we received in 25 was 268,068 applications paid. Unpaid was 157,381, which is the volunteer.
Yep.
New applications was 207,516. And renewal applications was 234,270.
And no one else here would have the figure of how much has been coming from the Working with Children check increased fee? Nope. That's okay.
Just let me. No, I do not.
That's fine. Ms. Ward, the reportable conduct scheme website has indicated that the phone line is temporarily unavailable. Could you explain why that is?
Resource issues.
Okay.
Yes.
Resource as in funding or?
No resources as a staff member to man it.
Okay.
So we do have an OCG phone line, which we do accept inquiries through, but the reportable conduct line specifically is closed, but we receive all applications through and notifications exactly the same way through our online portal.
So is that staffing because can't fill the position or?
They're doing the actual work of the notifications.
Right.
So yes, instead of having people on phones, we actually have people doing the work. As I said, we do have an OCG phone line, and we do receive information through that.
So are you intending to close the phone line or having a divert to another?
Well, at the moment, we are doing a functional review of the OCG, which is expected to take 6 months. I'm hoping that during that functional review, it will make some recommendations or some opinion on the way that we're currently structured. My view is that we don't have that centralised model of the OCG with a one intake, a one phone line, to enable that really crucial information sharing that I think has been a gap. And that is something that I would like to work towards this year, and that would then increase our ability to have that phone line open because we'd have that centralised approach.
And how much of that comes back to funding? Like, do you have enough funds to actually employ the additional person to do that?
It would probably be a redesign because we have those positions within each directorate. So I'm not sure if the way the OCG is currently set up is that each directorate very much operates in a silo. I don't think we can operate that, and certainly not my intention to operate like that in moving forward. So the aim is to look at these centralised functions that we can have across the OCG using the staff that we have.
And what's your current operating budget?
75 million is our complete budget, plus the 5.5 additional.
And that's inclusive or bringing it up to 75?
Yes.
Yep. Okay. I might move on. Portable long service scheme levy, where we've seen a 1.7% increase. I've had representation from a number of organisations, some in the disability clearance sector, some more broader than that. But the concern is around the financial cost onto some of these organisations to be able to pay that levy. Interested to know if you have any information on that, or any way is the government looking at what supports could be available for some of these organisations?
We did do some modelling in terms of the likely impact of the 1.7% increase, because as you know, most organisations should be actually accommodating for that portable long service leave prior to the changes that came into place. So we estimated it to be an additional maybe 0.5%. Obviously each year the New South Wales Treasury indexation comes in, and this year it was 3.5%. So I haven't got any feedback at the moment as to NGOs not being able to manage that. In most other states, the rate or the levy ranges from 2 to 2.34% in the Northern Territory, so I'll take that one out of the equation. But 2.2 to 1.65, and I think the only one that's a little bit lower is Queensland at 1.35%, but again, none of those states or territories provide additional funding to the NGO sector.
Yeah. Have you had any representation made by the sector? People have raised it in the past, more recently last week, but not necessarily in the context of this particular one, more the accumulation of workers' comp, the insurance, and the portable service, long service leave. But they are things that people should be accommodating within the funding that's allocated from government, particularly with the indexation, which is, as the Minister said this morning, much higher than a CPI. So a 3.5 is actually quite generous when you compare it to some of the funding indexation rates at the Commonwealth level. Okay. Now, I might actually go back just on clarifying a couple of things from this morning in relation to the young people in motel, hotel and caravan parks. My understanding, and I've had a number of caseworkers from across the state that have raised this with me, that there are young people in motels and caravan parks. Now, I just want it on the record, is that the case? Or are these caseworkers providing misinformation?
That's me. So my advice from my team, my staff who manage the HCA program, high cost emergency arrangement program, is that hotels, motels, etc. are used as we discussed this morning, but we use apartments within those institutions. We don't use individual hotel rooms for those emergency arrangements. So the organisation provider will be called a hotel or a motel potentially, but we will access the apartments which have separate bedrooms, separate lounge room, separate kitchen, laundry facilities, sometimes multiple bathrooms, so that it is as close as possible to a home-like environment. And we will use only accredited workers to supervise children in those properties, which allows us to be more confident around safety, and it allows children to have privacy in their room, workers to be in the next room quite close by. And depending on the situation and the location, it can enable things like school to continue, family contact to continue.
And in relation to the reporting as to whether the young person is attending school or not, is that reported into the department on a regular basis, or is it something that has to be requested?
Well, these children all have caseworkers,
Yep.
and part of the caseworker's role is to monitor things like school attendance.
And I suppose it goes back to the first question of, are you confident that that is being assessed? And we've heard this morning in reports, obviously caseworkers are quite stretched across
Yep.
all districts. To what extent have they got the ability to do that checking, or are they relying on these providers to report whether a child is at school
Yeah.
or not?
Well, they do check. That's their role, is to be across all of the arrangements in place for that child, all the risk factors, all elements of the case plan. That is the role. Now, if there's examples of where that's fallen down, we would be really happy to look at it, of course, and we accept that it's not a perfect system. And for example, we have not got our quality assurance frameworks completed yet. So when quality assurance frameworks are properly in place, we will have much more effective ways of testing that from the centre of the department, from the program itself, rather than just relying on individual caseworkers. But those things are being built. It's part of this very complex reform work to put all that in place.
Okay. Just a broad question. It's been just about the Transforming Aboriginal Outcomes Department. Is there any plans for any restructure or any changes around that?
That is, if I begin, and Ms Jarrett, if you wish to augment my response, you should. TAO, as I think the committee would be aware, was established in late 2021. It is possible, so there is nothing that has been finalised in terms of proposed restructure. What I would say about the Transforming Aboriginal Outcomes Division is that the Closing the Gap agreement, as I understand it, and as I have learnt about how that agreement can work from Capo, it's about genuine partnership, which means for an agency like DCJ, embedding functions in the department across so that there can be that genuine partnership. So I think there comes a point at which a designated function is probably not the most contemporary response as the organisation matures. There's a point of maturity where that needs to change. However, in saying that, there would need to be consultation with Capo, with obviously APSEC and the ALS, and with our staff. And in seeking to do that, and acknowledging the remarkable work undertaken across the agency by the Aboriginal staff who work in DCJ, also ensuring that we are careful and dutiful in the way we go about the consultation. So there will come a point, there is contemplation of that structure evolving, but as I've said, that is something being considered at the moment, but nothing has been finalised.
Okay. Ms Jarrett, did you want to comment?
Only to add on that when the division was established in 22, it was established by inheriting two ongoing funded teams, and then new additional teams were added to that in a temporary capacity with the view that they would become ongoing later on. That never transpired, so there have been significant budget issues since that time, so that's another factor. The division also spans across a number of portfolios, so child protection, out of home care, domestic family violence, and also courts and criminal justice programs. So there are some structural changes that are needed, and we're just working through those at the moment.
And will it result in changes in staff increase or decrease?
I don't think it will. So there are some temporary roles that we need to look at that may not be able to continue, but certainly the ongoing funded roles will stay as is, and we just need to figure out how we support some of those temporary functions to continue.
Okay, thank you.
Yeah.
Thank you. Can I just ask and go back to the Ombo report, and I think it's probably you, Mr. O'Reilly, or Mr. Tibble if you want to direct, but just in relation to the, my observation around the 28 days and that kind of, I mean, maybe I read too much in terms of what the Ombudsman was saying, but it just seemed that was such a problem red flag.
Yeah, it is.
And what is happening as of today. And I will go to my colleague when we finish this question,
Sure.
if I can.
Yeah, it is significant. Now, the 28-day policy setting, it's not compulsory, it's not enforced. It's a guideline that was put in place some time ago. And it has been put in place to provide some guidance around closing matters. But staff can let that time frame lapse and continue to work on matters into the future. They can hold them open for as long as necessary, and they frequently do. The Ombudsman finding, though, is that the 28-day setting is problematic, as you say, Ms. Higginson, for a whole range of reasons, and it is our intention to remove that policy setting as soon as possible. As I tried to say this morning, and I'm not saying this to overcomplicate matters, but a careful reading of the Ombudsman's report reveals just how complicated this is and how many times over the last 15 years people have acknowledged that it's complicated and have not managed to fix it. So that is a really important warning to us that we don't get this wrong and we don't make rash decisions and start pulling threads out without understanding the aggregate impact of that. So in the next couple of months, we will implement some policy changes that will address the key practical or practice issues. They are things like that 28-day rule, for instance, making sure that staff have consistent guidance around the prioritisation and ranking of risk when they're looking at matters to help them make better decisions, less reliance on collective decision making and much more clarity around documenting who's involved in decisions and who's accountable for individual decisions. It's another finding in the Ombudsman's report that we need to implement. And we need to give people tools around documenting and justifying their decisions for closing reports. Now, if it is the case that there are numerous reports on the desk of a casework team and they cannot get to all of them, we have to give staff tools for ranking those matters so that we can all be confident and transparent that the decisions we've made to prioritise one over another are the right decisions. The Ombudsman's made a couple of recommendations about transparency. One of them is that those decisions about prioritisation are reported centrally to the department by all casework teams on a quarterly basis so that we can make sure that we're getting it right. They're the kind of things we need to build in the next couple of months so that when we implement those policy changes, we can be sure that we've implemented those recommendations to the Ombudsman's satisfaction, to our own satisfaction, to the committee's satisfaction. And I think that's why the Ombudsman has asked us to take 2 months to think carefully about how we plan that and how long we think it's going to take. We won't implement everything in that report in the next few months, but we will certainly deal with what he sees as the most egregious problems, or we feel to be the most serious problems. And that prioritisation and ranking and 28-day policy setting are pressing matters that we need to deal with as quickly as possible, but not in a way that's cherry-picking or reckless. We have to make sure we understand all of it, because in all those changes, which are quite profound, we have to be confident we're giving staff direction, support, leadership support. Line managers have to be confident they're going to be backed into those decisions. That all has to be built really, really quickly.
Can I just ask, before I hand over, just when you talked about the collective decision making, and I know that that's one of the, what
what is happening now that you think is in need of improvement?
This was the Ombudsman's finding
Yeah.
in relation to allocation meetings, and so we need to have a look at that and work out what aspects of the allocation meetings are problematic that need to be addressed.
And you're not, at this point in time, because there wasn't much more on that. It wasn't like it was, this is what should happen, this is where it should be going right now. It looks, it's like identifying problems.
My interpretation of that finding in the report was that decisions about prioritisation and resource allocation need to be transparent, and we need to document who was involved in that decision, who was a senior person involved in that decision. That needs to be really clear, and the Ombudsman's view is that it's not clear now, and we accept that, so we have to build all of that. And so one of the elements of that piece of work is working out how does collective decision making impact our ability to be transparent, because
and accountable.
Because ostensibly group decision making can be a good thing. In public administration generally, group decision making can be quite helpful, but in this case we've found that it gets in the way of that accountability and transparency in justifying what are really hard decisions.
Thank you. I'm going to go to you, Ms. Boyd.
Thank you very much. Can I go to you, Mr. Smith?
Earlier I was asking about restrictive practices, and it sounds like you have had a bit of involvement in that so far. Can you give me any update on the work that's going on around restrictive practices, and particularly whether it's being looked at as to whether the ADC will play a role in that restrictive practices framework?
It's still unclear. We were co-locating with the restrictive practices team for some time, but given that the impetus for reform seems to have slowed, then that team has co-located back to DCJ to work with their policy team. And that kind of makes sense insofar as there is an opportunity there for, to be with other policy colleagues in that space. So but it seems like a pretty clear message there that is not imminent in terms of reform, part of the reform agenda.
So we're not at the point of then looking at, sort of how that would impact on resourcing or things if you were given a role under that.
Not at this point,
presumably it would be quite a large role. Can I ask, in your experience, are you seeing anything in terms of trends? We were hearing that there's been an increased trend towards guardianship models and away from just supported decision making, necessitated by the NDIS process itself, by needing to actually, have somebody complete forms and things within NDIS, and that instead of taking us, towards that more, giving more autonomy over decision making to people with disability, NDIS has actually resulted in it being less, because then people have had to have guardianship in order to complete forms in order to get their payments and things. Is that something that you have seen? I've only heard this anecdotally. Have you seen anything in your work that indicates an increase in or a problematic use of guardianship as a result of that?
So it did actually arise. I was at the National Forum for Australia's Disability Strategy, and a similar question was asked. I was on a panel of a number of my Victorian counterpart or colleague and myself. It is clear and fair to say that there are kind of institutional barriers in place, if we can call it that, that do kind of push us towards a substitute decision-making model. When, in New South Wales, I think we are in a little bit of more of a push-me-pull-you state, where there are clearly moves towards supported decision-making in a policy and administrative sense. And obviously the work of the Commission is very much lined up with supported decision-making. It's built into our statutory framework. It colours and guides our actions right from the moment that we take a call right through to an investigation. So, but yes, I think it is absolutely fair to say that those we are still institutionally in Australia and in New South Wales at a point where some of the policy levers are pushing us towards substitute decision making, and others are, and the advocacy groups and organisations like the Commission are very, very keen to go down the path of supported decision making.
Something we've spoken about previously, or at least I recall, I'm not sure if it was you or your predecessor, but talking about the use of a lot of problems in group homes, but particularly the use of restrictive practices in group homes. Are you seeing any sort of trends coming in from people contacting you in relation to group homes now? Have you got any data or any sort of insights into those issues?
The only insight would be around, can I take that on notice, around our work in the official community visitors scheme.
Yeah.
And we're clearly getting some insights back from that, but yes, I can come back to you on that one.
And then I think final one for you then, Mr. Smith, is in relation to the coercive control, criminalisation of coercive control that came in a couple of years back. We know that there will be a review from the beginning of this year. One of the big outstanding questions around that legislation was the definitions around the groups of people that it would apply to, or the types of relationships rather that it would apply to, whereas the broader personal violence offences apply in a variety of situations, including, I believe, boarding houses and other things. The coercive control reforms only refer to intimate and former intimate partner. Is that, I guess, in preparation for that review that starts in July, is that something that you are looking to sort of get more data around in terms of what you might view as the use of coercive control, particularly for older people and people with disability?
Well, our position has long been that we would have liked to have seen that provision extended beyond intimate partners. And so, yes, we will be, it would be our intention to engage in that process and bring forward evidence, data and argument to that effect in terms of how it's been working so far. And part of our belief is that, in any legislative change, you need to do more than change the legal mechanism, and there's a whole suite of things around that, around awareness raising and education, which could usefully be done.
Thank you. Ms. Ward, I know that there's been this review going on into the Working with Children Check scheme more broadly, and apologies, I know that Ms. McLaren-Jones was asking questions about this as well, but I don't think this bit got covered, but I'm sort of interested in where that review is up to, and when we expect to have a sort of, I guess, a policy proposal coming out.
Shortly, I hope. So public consultations closed just Friday, just gone, and I did give some evidence that we did get a lot of responses as expected, 2,000 from the New South Wales public on Have Your Say, 78 guided positions, and we've given some extensions to some of the bigger organisations that wanted a little bit more time to consider some of the proposals. But we would hope by October to have a report ready for the Minister to have a look at the feedback.
Okay.
And that's over the whole Working with Children Check Act, just to make sure we're talking about the whole thing.
And in previous estimates, this will predate the Have Your Say and the current reform piece, but there was been a lot of focus on the frequency with which people need to get Working with Children checks, and in particular the rules around when you join an organisation such as the police, you may need to have a Working with Children check to begin with, or if you join the Fireys or wherever, but then you're not required to renew that over time in order to continue to have your job. Is that part of these reforms?
It is. So not necessarily part of the reforms just yet, but it has been included in the discussion paper because they are elements that have been called out by estimate committees,
Yeah.
New South Wales Public, about the things that have worried them, and that is included in the discussion paper for comment.
There were a number of, or at least two that I can think of, reforms last year in relation to the way Working with Children
Yes.
checks were working.
Internal review.
Yeah, how has that played out? Have there been any wrinkles in terms of, and I am particularly interested in the early childhood space and the way that the interaction with the regulatory authority and in terms of telling you when people have had a prohibition order and things like that. How is that working? Are there any sort of hiccups or things that need to be fixed?
So there's two parts to the question. So I'll answer the early childhood one because I know that is a particular focus of yours. So as you know, the Early Learning Commission commenced last year. In December last year, the OCG and the Early Learning Commission signed the Memorandum of Understanding, which was to be the way that we would work and the information that we would share with each other, all within legislative frameworks, but really giving each of our staff the confidence in what information should be shared and when, and the intention of that. In terms of prohibition notices, I do have some numbers. So between the 1st of July 25 and the 31st of December 25, they notified us of 101 prohibition notices, keeping in mind these are national, so they might not have been New South Wales Working with Children check holders. However, using our due diligence, we do save those names on our Working with Children check system in case that they do apply for a check in the future.
And was that 101 not just new ones, but also ones that were already in place that needed to now be put into the system, or were they new?
There was they were new, and there was an additional, the category that you're talking about was 235.
Okay, so 235 that weren't previously known to you are now known to you, plus an additional 101 since then.
Correct.
That's very useful, thank you.
Yes.
Okay.
And in relation to our, the second change, which was the internal reviews coming into the OCG, there hasn't been many wrinkles to date. We have received 48 applications for review, and I did give some evidence to Ms McLaren-Jones that we have set that up as a standalone separate team, not within the Working with Children check team, but using the same frameworks, of course, and they report directly to the new Deputy Children's Guardian.
Okay. All right, thank you. And is there, I guess, are there any missing bits of reform in that space that you're noticing just as you go that might be another thing for us to focus on?
I think as I get some more cases come through, particularly around some of the themes, I think it will be really useful for us to look at as to whether or not we need further legislative reform. There has been some issues, particularly around the negative notice issue, when we follow other states as to who put it on first. There's a bit of a ping pong effect happening at the moment. But I don't have as many case examples of that just yet to be able to give you an educated, informed view, but is something that's definitely on my radar.
Okay. Thank you, Chair. That's all I have for these two witnesses.
Yes.
So if you wanted to, I could go back to you.
Okay, thank you very much. I think
I've got one.
Okay,
Yeah, sorry. Just Ms Ward, just in
And then
relation
we'll
to for-profit organisations, obviously a number of have become accredited in the last 12 months or so.
Yes.
Have any of them had any restrictions placed on them?
The for-profit organisations? Let me just check. I have the list here. I'm just going to cross-match them.
No, that's fine.
No.
Thank you.
Can I just briefly, is that all you have?
That's all for me. That's fine.
I'll come back to you guys in a second. But can I just raise a point? Earlier this morning, and I think it was you, Mr. Tipple, this was in relation to the joint protocol that was discussed earlier that I raised that hasn't, the joint protocol that was developed in 2016, and that I think it was said that the ALS and Legal Aid were part of that steering committee for the joint protocol. But it was called out to me during the break that both the ALS and Legal Aid are not part of that steering committee, and in fact were removed from that committee in a restructure of governance. They are on what's referred to as the implementation committee, which hasn't met for some time, and the word on the block is the ALS and Legal Aid would very much like to be in the steering committee. That is the word on the street.
So
The word on the street is they want to be back on that committee.
All right, can I just be clear? So we
Yes.
traversed a lot of territory this morning. We're talking about the police DCJ committee.
Yeah, it was the New South Wales Police Youth Command's part of that steering committee of the the Police Youth Command, and yeah, this is it's an alternative escalation pathway that's been developed for this joint protocol.
So Ms. Higginson, can I take your question, which is put in good faith at face value, and take that away?
Please, yeah.
I'm also happy, because he's actually part of the justice grouping, to in regular liaison or structured meetings to raise it with the police commissioner. But if I can take that away on notice, to the extent that my answer may have been imperfect, I'm very happy to correct that on the record if necessary, but also in terms of ensuring that it's fit for purpose and contemporary and embraces Legal Aid and ALS and the other key stakeholders. Happy to take that away as well and report back.
Thank you. Thanks very much. All right, so look, just before we go back to the opposition, I think Mr. Smith and Ms. Ward, I think that the committee is happy to let you go, if that's what how we refer to it. I think that, we're finished with you, and obviously incredibly grateful for your time and your evidence today and providing all the assistance to the committee you have. So thank you both.
Thank you very much.
Thank you.
Right, so we're back to questions from the opposition, please.
Thank you very much. The questions related to sort of Roche reports, so I'm not sort of sure whose space that might be. Thank you. And look, it follows sort of anecdotal reports, media reports relating to Sydney Support Services, disclosing they're receiving weekly, sometimes daily calls, mostly from girls and young women. These are minors, relating to issues around forced marriage. I'm just wondering, just from a Roche report perspective, just wondering whether we're seeing anything in this space or an increase in reports.
No increase.
Relating to sort of this cohort.
I don't believe so. I mean, forced marriage is a serious crime and will remain so, and will remain a serious risk indicator for us. But I'm not aware of a change here.
No, so I understand there have been 14 young people reported with concerns about underage forced marriage in the last reporting period. Each one of those, where appropriate, we have liaised with the AFP as per the agreed protocol. So just to reiterate Mr. O'Reilly's comment, it is a serious criminal offence that the department certainly takes very seriously in regards to suspected risk of significant harm for those young women. Where appropriate, like I said, we liaise as per the agreed protocol with the AFP. So we have met our mandated position for those reported young people.
Thank you. And in a similar area, this would be, anecdotal reports relating to young women and reports of domestic violence. And I'm just wondering, in instances like this, in terms of what would trigger like a mandatory report would be possibly through the police, which may then alert you guys to something. Would that be right?
Are we talking about domestic family
Yes,
violence or
correct.
in relation to still underage forced marriage, Ms. Murray?
Sorry, I'm domestic family
Yes,
violence.
Yeah. So we can receive risk of significant harm concerns in relation to domestic and family violence from a variety of people in the community, including mandatory reporters and non-mandatory reporters.
Mm-hmm. So in terms of non-mandatory reporters, just in a, could I just have some examples of how that might take place?
Oh, of course. In relation to domestic and family
Yes.
violence concerns, it might be a neighbour that
Right.
lives in the same street that
Yeah.
might see some behaviour that is concerning or worrying for them.
Mhm.
It might not be concerning or worrying enough to call police for immediate response or action. Of course, there's the other end of the continuum where, of course, the police are called and then they may in fact report to us also.
Mm-hmm. And in terms of the, in terms of sort of police reports here, in the event of a minor, like, you know, teenage girls reporting, and I preface by saying this is anecdotal evidence that's been put to me. So young teenage girls feeling under threat, reporting, calling the police, reporting instances of domestic violence. As a consequence, the, you know, alleged, you know, perpetrator then appears in court. The concerned minors are then part of that process. And then, you know, clearly it's case by case on something like this. But I'm just saying that, you know, then there are reports that with the, you know, with the alleged, you know, perpetrator there in the same court setting, these girls are withdrawing allegations, and then people say, oh, and in 2 weeks' time we will see this again. So just from a child, sort of the family sort of domestic violence situation, what would be the touch points with you guys on this? Would it be triggered by a mandatory report from a police officer, or?
If I understand your question correctly, Ms. Merton, it could be, we could essentially have a number of trigger points initiated.
Yeah.
However, I think the setting that you're describing is probably more a justice-focused question as far as what support's being provided in the court space to be able to support those people to give evidence and then not retract. There's a range of activities that happen in that space to be able to support young women, or in fact, you know, any victim of domestic and family violence, regardless of gender.
Mm-hmm.
But in relation to if it's a young person under the age of 18, it's really only a child protection concern if that young person's parents are not available or act inappropriately. So it's important for us to differentiate that, because domestic and family violence may have occurred, if for a young person, if their family is acting appropriately, then that may not trigger a rush concern in for the helpline's consideration.
Mm-hmm, mm-hmm. And then overall, you were saying just in terms of the number of reports relating to Roche, we're not seeing an increase in the last 12 months.
That response was in relation to the underage forced marriage.
Okay.
If you give me a moment, I can find some
thanks.
Roche data for you. I think it's about 8%. But give me, it is, yeah. I think it's 8% of our risk of significant harm concerns that we receive identify domestic and family violence as the primary reported issue, noting that sometimes there are multiple reported issues.
Okay, well, thank you.
Thank you. I just wanted to examine a bit more about when a young person absconds from a placement, and looking probably more at the sort of the IPA or the high cost placements as opposed to foster carers at this stage. If you could just outline that process. So a carer notices that the young person has gone missing. What are the steps and time frame of reporting it, and what happens?
There's a range of activity that I'll jump in, and then Mr.
That's how I'm
O'Reilly
looking at everyone.
can jump in if needed. So look, there's a range of activities that occur as far as steps. Generally, when young people leave placement, it can be for a variety of reasons. They could just be going for a walk, they could be going to the gym, they could be going to meet with a friend. It is in relation to the policy I think you might have been asking about this morning, and in relation to that, it is when a young person is absent from their placement for more than 5 days. That is when the criteria kicks off for a critical incident. Now, that scenario, when a young person is in the PR of the Minister, the policy identifies a Category 1 critical incident, which is escalation to the Minister, obviously via the chain of command, via the secretaries, of course, which is the case for missing for more than 5 days.
So going back to the steps, what happens between when the young person is found to be missing and 5 days later? What are the steps in between?
So a range of things. Young people can obviously still be in touch with their caseworker. So technically they're not missing, they're just not in the placement. The young people in, for instance, you talk about high cost emergency arrangements, you talk about IPA, you might also be suggesting about ITC.
Yep.
So in relation to that, their casework team generally stay in touch with the young person. It really obviously escalates in risk and concern when people can't contact them, or if in fact the behaviour becomes out of the ordinary. Some young people, quite regularly leave the placement for an afternoon or go to their friend's house for the night, and then they come back the next day. So the concern, of course, is around when does the behaviour become out of the ordinary or unusual for that young person, and of course contact. There might be then a range of things that young people or carers then try to deploy, such as contact with family, contact with friends, obviously liaise with the police when needed, and then notify us as well, remembering that the department does not have case management for all of those young people.
And this morning, I suppose the term, and Mr O'Reilly referred to it as degree of risk. Could you outline how that is, I suppose, determined? Are there guidelines for caseworkers to be able to make that determination as to what level of risk is a young person at? And I'm noting that caseworkers are very qualified, so it's no reflection on them. It's just how, because there's a lot of pressure to put on someone to make a determination as to what extent do you escalate.
Do you want me to jump in? Yeah, so it's really around, so our workforce do a great job, regardless of whether they're employed by the department doing a statutory child protection out of home care role, or in fact whether they are workers with the sector supporting case management when the NGOs have case management. So absolute shout out to them, they do a terrific job. Like I was saying, the risk assessment really sits in the space around what is my relationship with the young person? How do I know that this behaviour is either normal or abnormal? What else is going on? So obviously young people might be threatening to hurt themselves. Of course, that would escalate our concerns. Notification to police or health, etc., would be activated much quicker. So it's really around what's going on for the young person. What do we know is happening for them? What's the kind of few days been like prior to today, if there's been an incident for them? And then certainly very much about what's normal, out of character, within character. What do we know about them? So we know sometimes young people under pressure don't always make great decisions. They meet up with people that perhaps we might not think are great people for them to hang out with. We work with those young people to help them make the best choice that they can to help them stay safe. But certainly over the age of 16 as well, we have to also be led by the young person around what's going on for them and where they want to be. And from a risk perspective, of course, we engage other professionals such as the police or health if we're concerned about their welfare.
And then, so obviously I think it's 60 or 70% of the more high cost placements are with not within the department, obviously with NGOs or for profit. What is the pathway of, I suppose, advising DCJ? So when a young person's absconded from one of those IPAs where DCJ staff don't have direct oversight, what is the reporting expectation to escalate it to you or to the Secretary?
Yeah, so in relation to young people who are case managed by the sector, and I think you suggested a percentage, I'm not sure that's a right percentage as far as high cost emergency arrangements for case management,
so
either with the department or the sector.
But IPAs, sorry.
Yes, but if we're sitting in a space as far as ITC, for instance, or in fact the high cost emergency arrangements, regardless, If the sector has case management, they are required by the policy to follow the same kind of process that the department does.
And so, again, I hypothetically, I know we're not meant to put hypothetical questions, but if you do have an IPA that is being managed not by DCJ, but by a for-profit, a young person absconds, when would, and they would be deemed at risk because of certain things they may be saying or acting out on, when would DCJ be expected to be notified? Is it before or after the police? Is it at the day 5 period? When would that level of escalation go to the department to be aware of an incident?
Yeah, generally if the agency is reporting to police, you would think at that point they would also be alerting the department, given we are the administrator of the parental responsibility sitting with the minister. It does depend case by case, because we can't necessarily prescribe every step on every occasion for every young person. Depends on what's happening, and things can escalate and de-escalate very quickly for those young people. But there is an expectation, of course, that if case managed by the sector, they would let us know. In relation to for-profit, that's irrelevant as far as what the requirements are in relation to contract management or not with the department.
And is any reviews or audits done as to whether or not that reporting is actually occurring?
Yes, there's a couple of things that happen. Obviously, at the point in which we get notified, we do our own due diligence check around when the young person actually went missing. We'll identify, for instance, through my chain of command in my space with my excellent team, they'll essentially identify if the young person went missing 7 days ago and we got notified 7 days later. Obviously, that's a breach of the critical incident management escalation policy. We then liaise with the contract manager of that agency to let them know that we've got a concern about that. It gets raised with that agency via contract management levers. And
could you take on notice, I suppose over the last financial year, or whichever is easier for reporting, the number of those breaches have occurred across the state?
Yeah, we can take that on notice. I'm not sure that we count that exactly, but I'll do our best to share with you, Ms. McLaren-Jones, what we can in relation to that data capture.
Thank you very much. Just in relation to for-profit providers, and are there any audits that are done around compliance, financial integrity, or any potential conflicts of interest in relation to their operations? Have any been done?
All funded services are subject to compliance requirements, conflict of interest policy, and audits periodically. Like anyone who receives government funding, particularly through us, is subject to those activities.
And for the for-profit organisations, have any of them, I don't require you to list the names, but have any of them undergone those type of audits in the last 12 months or 2 years?
There have been audits in the last 2 years. I'd have to check which category they were in, unless one of my colleagues is aware. I'll have to check that.
Yep.
Certainly, I can't comment on for-profit providers, but we have done a look at all the out-of-home PSP providers and looked at their income and expenditure, and also looked at them declaring conflicts of interest. We did a project last year where we actually found quite a number of conflicts of interest that hadn't been disclosed. So what we did then is also tighten up our own policies and procedures, and also information to the sector. We've run some training sessions with NGOs so that they're very clear, and we've done that in conjunction with, for example, ICAC as well. So there's quite a bit of work, I think, about standardising some of those practices that perhaps haven't been perfect in the past.
And is that been done for the for-profit sector as well?
Anyone that's funded through the PSP program.
Okay.
Yep.
Has there any evaluation done around the use of for-profits versus NGOs versus DCA in delivering of high-cost placements?
Not exactly in those terms. We have a preference to not use for-profits. That is the policy of the government, or the position of the government. And we have certainly reduced the number of for-profit services. But as the Minister said this morning, sometimes we need a particular skill set to respond to young people with particular needs. And New South Wales is a big place with a complex market, and in some locations the market is thin. And so we will continue to use for-profits where we need to, but it's our preference to not use for-profits. There is a preference for case management for children who need emergency arrangements to be with the department, and there have been times when we have transferred case management to the department. It gives the department and the minister closer access to the case management levers to try and resolve the drivers of the need for an emergency for that child. However, it's not possible to automatically have case management of all those cases when the placements break down and they need a HCA. The out-of-home care strategy, which was announced last week, is an opportunity for all of that to be reset potentially, where the department has carriage of all complex cases into the future, where the likelihood of a HCA being needed is greater. The department should have case management of those matters to begin with under the new policy settings as that framework is rolled out. So that will improve access, and that is a reform policy position we're going forward with in the absence of an evaluation, in the sense that we're not formally evaluating for-profit versus not-for-profit versus DCJ for management of HCAs. Our aim is to reduce HCAs down to the bare minimum through the policy reform, with DCJ taking on complexity far more than the sector.
And the announcement that you referred to last week, is there funding attached to that strategy as yet?
Well, the program is already funded, and the strategy is about changing the way that we spend that money based on what we've learnt through all of the reviews and all of our reform work. So, glad you asked. The contracts with PSP were due to expire next year. They'll now be extended. So for home-based care, extended by 1 year. For residential care and ITC, extended for 2 years. And that gives us a lot more time to properly evaluate ITC and redesign the program so that we are investing that same budget far more effectively to get much better outcomes and try and overcome some of the challenges that PSP just has not overcome. For instance, funding agencies in a broad, flexible funding package for the continuum of care across the state has not worked. But there might be a lot more sense in funding NGOs for low needs long-term care for the placement, and the department might, for example, subject to some design work, might decide to fund restoration work separately, for example, rather than it all being one broad, flexible funding bucket for each child in those agencies. So, same funding envelope, but administered far more effectively based on what we're learning about what we need in our investment.
Okay.
Can I just add to that, though? That's against a backdrop of a significant budget announcement for the 25-26 year, which, and all of this is probably known, but the $143.9 million to increase foster care allowance for the first time in 20 years. Similarly, the $779.6 million to continue supporting children and young people in out-of-home care reform. So while a reform process is in place, so whilst the funding is allocated, it's against a backdrop of a very significant injection of funds in the 25-26 year and beyond.
Thank you.
Thank you. With the announcement of the new strategy, and the failure or the identified failure of the PSP, I'm just. Sorry, I've lost my thing. Here we go. Yeah, with the Sunday announcement, there's some questions that have come through about the strategy speaks to the establishment of a cross-agency child safety and wellbeing forum reform. Are you able, or do you know already, what agencies will participate in that forum?
Yeah, sure. So this is a response to recommendation 1 from the review into out-of-home care, the system review, from 2024. Mm-hmm. So this recommendation talked about the establishment of a secretary forum with the key agencies involved in supporting those children to address some of the service gaps, particularly in relation to quality of care, access to education, and access to the health pathway and the performance of those systems. And so the department has been working with health and education and treasury in the Cabinet Office to consider what that could look like. And we have obviously consulted with our minister and the relevant ministers, and we hope to have that forum up and running in the next few weeks. And it'll be chaired by our Secretary, Mr. Tidball, and secretaries from Health, Education, Treasury and the Cabinet Office will be on the committee as well. And the committee will interact with other groups as needed. For example, there might be a need to interact with police, Aboriginal Affairs, other organisations, and it will consider, subject to the terms of reference being ratified, the really critical issues that affect these agencies. For example, establishing a meaningful, efficient joint data set across those agencies, identifying the kind of integrated, bespoke health models that are needed for children in the out-of-home care system that might be different to the general mainstream services that are available in most health districts at the moment. That's another one. And in education, it really will be about trying to work out how we improve the data set and do the kind of work we need to do to support children to attain education outcomes and be more successful when there are challenges. For example, placement changes have an impact on education outcomes. A more integrated approach should be able to predict and preempt and support kids if there are changes needed. Contact with family can sometimes drive a traumatic response which affects attendance at school, affects behaviour at school. All those sort of complex issues that we know exist in this cohort, education and DCJ working together more effectively. And the other thing we would acknowledge is in education and health there are hundreds of staff who work with out-of-home care and do a great job and are very expert. In DCJ there are thousands of caseworkers who are also very expert and committed, but the coordination needs to be more effective. And that is really what that wellbeing committee is trying to drive.
Right. And then will there, or what plans are there to engage stakeholders in the development of the cascading strategies that provide the detail of that?
Of the Secretaries Forum in particular?
Yeah, well, actually of
the cascading strategies around residential care and...
particularly around restoration.
Restoration? Yeah, absolutely. So the department will lead the development of a restoration strategy. That work is starting and we will work with all the relevant stakeholders. That includes our colleagues in CAPO, of course. It includes other NGOs and peaks who want to be involved in that work. We'll work closely with AQUA, of course. We'll work with young people and families. We'll work with carer groups because the role of the carer in supporting restoration is absolutely essential. And we would work with other agencies that have a stake in the development of that strategy. We would clearly work with our legal team, we would work with the Children's Court and all of the other players, I suppose, or participants in driving a better response in relation to restoration.
Okay. And that's, I mean, I think that's kind of what's at the heart of the strategy, right? In terms of that restoration work is how we take what's not working and bring what is and
with a sense of urgency.
Yeah. Jumbunna and ABSEC published the paper. I think I raised this at the last estimates, was waving around, and that was the Strengthening Accountability for Aboriginal and Torres Strait Islander Families, which outlines two complementary models for strengthening accountability. One of those is a specialised independent commission. Is this something that, is there any work happening alongside this with the out-of-home care reform agenda?
The Minister gave evidence this morning about the recommendations to establish a commission. That's I can't really add to that evidence.
Yeah, okay. But is it fair to say that report is now kind of well populated within the department, like with all of you in terms of the work that's happening?
Well, certainly the report's helpful. I mean, it talks a lot about developing shared vision. It talks about systemic change and embedding KPIs in leadership in the public sector. Like, they're really important reforms that we need to drive, particularly in relation to closing the gap. Overrepresentation of Aboriginal children is, in my view, the most serious challenge we face in this sector, and so we absolutely have to consider Jumbunna's advice, recommendations, and work out how we can include those capabilities in our leadership.
Thank you. The February 2024 Families Culture Progress Report noted as next steps for recommendation 9 indicated that it was under consideration by the New South Wales Government, and it was anticipated at that time to be considered at by the MAP group, the Ministers group. Can you advise, has there been any progress on considering this and whether it has in fact been a consideration of the MAP group?
Can I take that on notice? I just don't want to speak for the MAP group. I'm not a member. I visit the MAP group and report too, but I'm not a member, so I might take that on notice.
No, thank you. Thank you. It's the joint protocol. And then... yeah, look, I wanted to raise... So in the OMBO report, made reference to the issues with, so the Roche report, but in the last few years there is particular attention being paid to child sexual exploitation of children in the out-of-home care system, and responding to sexualised behaviour of children and young people in care. Findings from the mixed methods survey point to the need for upskilling frontline professionals about the distinctiveness of child sexual exploitation and practices they can engage in to both disrupt that exploitation and respond sensitively to victim survivors. Under Pillar 2, the early intervention of the New South Wales Sexual Violence Plan 2022 to 27, one of the targeted interventions listed as a focus area is to implement strategies to prevent and respond to sexual exploitation of children and young people in out-of-home care, including those leaving care.
Yes.
So there's a lot there.
Yes.
It's all those staged and those important work. Can you advise what progress you have made to develop and implement such strategies, and who were they developed with, and how are you monitoring that work?
So that work's not complete. We're beginning that work, but it is... Going back to the beginning of your description there, Ms. Higginson, where you talked about the need for workforce to be much more attuned to the risk and more sensitively responsive to the risk, that goes to our broader challenge around workforce capability and workforce reliability and supply in the out-of-home care sector, which is an enormous challenge, as documented in most of these reviews. The challenges for workforce in foster care, casework, are unique. The challenges for workforce in residential care are even more intense. And so part of our redesign of residential care, announced on Friday and Sunday in the out-of-home care reforms, is about working out how we improve the conditions for workforce and how we develop a workforce that is capable to respond to the unique needs of that cohort. And the risk of sexual exploitation is one of those unique risks for that workforce, as you've described in your question. Across New South Wales and across most states in Australia, there is not yet a unified workforce capability set for this workforce, particularly in residential care. So we're working at the moment with registered training organisations to try and negotiate how we can establish a capability framework for the residential care workforce that responds to that, and make sure that we have workforce that are fit for purpose. One of the things that children and young people in residential care, in all out-of-home care, but especially in residential care, tell us is about challenges to do with the response of the workforce. It might be about high turnover of workforce. It might be about workforce being disengaged while they're in their homes with young people. It might be about workforce just not being attuned to risk, as you've described. They are live issues for us that we intend to address. And so part of it is about a workforce strategy that sets out up front what the capabilities are and recruiting to that. But the other side of it is the quality assurance work that we have to be putting in place to monitor quality, making sure that there are voices of children and parents in that quality assurance framework. That's really essential to getting this right. So the integrated quality assurance framework work is happening now. It's coming together now, and it needs to look at how do we monitor the quality of our workforce response in child protection assessment, decision making, foster care support and residential care support for young people, and whose voices need to be involved in measuring the quality of the work and then responding accordingly.
When you say that you're working with those registered training bodies, are you able to provide who they are? Is that something that is...
Yes, although I should say we haven't contracted anyone, we haven't
Right.
brokered a deal. What we're doing now is trying to work out who is best equipped to partner with us on this. We haven't found a partner yet.
Okay.
But we started talking to the major RTOs to try and work out how to best do this. It's a unique expertise,
Yeah,
and we need to get it right.
And so, do you, in terms of your time frame for that, have you got a kind of time frame of expectation and?
Yeah, well, the residential care program needs to be designed in the next 18 months to 2 years.
Yeah.
The evaluation is starting very soon.
So, yeah.
As the Minister mentioned
June.
earlier.
It was starting in June?
Yes.
Yeah.
Yes, that's right. And our contracting timeframe has changed in line with the announcement, but we need to have everything set a year before then so that we can then do a careful commissioning process. So in the next 2 years, we need to have resolved all of this.
And so is all of that, and this is probably a question for the Minister, perhaps the Secretary, I don't know, but so is all of this guaranteed financially committed in terms of the budget? Like, is all of that, we're not going to get somewhere and go, oh gosh, the blowout of the cost of implementing this
well, in terms of
residential
budget,
care program reform?
Yeah, so the budget is a recurrent budget.
Yeah.
It's secure. There's no cliff on the budget. And in the last budget, as the Secretary said, there was enhancement to make sure that any shortfalls were dealt with. So there is a strong recurrent budget into the future, but it needs to be spent more effectively. And that's what the reform is about.
Thank you. I just wanted to ask about if anyone could answer this to the best of your ability, and I accept that there's a cross portfolio here. But so presently New South Wales does not consider, or I'm told, does not consider young people leaving care a priority group for social housing. And I'm referring to there's several hundred young Aboriginal people each year exiting care in New South Wales to effective homelessness. One of the things is, compared to Victoria and Tasmania, New South Wales doesn't designate care leavers as a priority group for social housing. Is that something that you're aware of, or can you elaborate on?
If I may respond, to my understanding that's not accurate, Ms Higginson. To my understanding, young people leaving care is a priority group for Homes New South Wales in relation to housing. If any care leaver requires assistance, they are also able to contact after our leaving care teams as well. And we can advocate for them and with them in relation to engagement with housing services. But my understanding is that that they are in fact deemed a priority group. And wherever we have liaised with Homes New South Wales in relation to leaving care, becoming adults, there's nothing that jumps to mind that we have been unable to facilitate appropriate housing.
Right. Well, that's one of those answers that you enjoy hearing, right? And that's the same for the Aboriginal Housing Office.
Yes, you'd be aware, Ms Higginson, that with the establishment of Homes New South Wales, obviously that includes
within there.
LAC and also Aboriginal Housing Office also. Like I said, Ms Higginson, if you have examples of Aboriginal care leavers that are struggling with that, then please share with us offline so we can follow up on those concerns.
No, thank you. That's just, this was information that I was given and asked to ask about, and all right, thank you. And I'm sure if they do have examples, I will be able to pass them on.
And also, if I can just add, whilst they're a priority group, there's no guarantee. So we still have priorities. We still have, obviously, stock. We still have to find the right stock for the young person, and where they want to be versus where we might have available stock. So there's It's not as simple as they apply and we allocate them a house, but they're certainly they are certainly a priority.
A priority group, and I think that was part of the the information. I mean, it's no secret, is it, in New South Wales that we are radically undersupplied in terms of social housing that's available, and that's something that there's been a focus on.
And there's also private rental assistance as well, particularly in the examples that Ms Dean was talking about, that are available for young people as well.
Yeah, thank you. Thank you. And then, I was just wondering with the, I know the Minister touched on it, and I think maybe Mr O'Reilly, coming back to you, in terms of the restoring, the Aboriginal Authority for Restoring Children, when I asked the Minister earlier about, there were these claims that DCJ was improving restoration practices, but I think now we've realised that, with PSP, the admission now that it's not working and we need to move away, and obviously now with the change of direction. Is it the work that was happening and led by BJ Newton, that's not happening anymore, is it?
No.
Okay. And so the strategies there, we're taking a different direction. There's work being undertaken. PSP is failing, but what community-led restoration work is occurring now within ACOs that you can point to or provide the committee with? Hey, it's not all sitting in limbo while we redirect.
Well, it's not sitting in limbo. We're doing a number of things around restoration, and we plan, as the strategy announcement said, plan to develop and launch a restoration strategy as part of this strategy. There is a number of things happening, but what I would say is we have hundreds of Aboriginal staff who are also community leaders themselves, who play both roles, who have asked to be involved in leading some of this work, and that is what we intend to do. We intend to have an Aboriginal-led restoration proposal or program.
And to confirm, that will include, so it's not just, I shouldn't say just, in addition to the great people within the department, will this include the Aboriginal organisations and advocates outside of the department's employ?
We'll consult openly, absolutely, with whoever wants to. But what we can't commit to do is implement everything that people ask us to implement. And one of the reasons for that is that sometimes it's just not possible within the legislation to do so. So we have to make sure that we're acting within the legislation, and that any statutory responsibilities have to remain where they remain. But what we want to do is, in all of our casework allocation decisions, we have to make sure we're doing all we can to promote family connection as an urgent priority for every child, where it's safe to have family connection, to optimise the chance for restoration. And so when we are recruiting carers and briefing carers, we really want to understand what is motivating carers to become carers, and if they are not motivated or are not willing to work closely with birth families on supporting restoration, then they may not be suited for that particular kind of carer role. There may be another carer role that's more suitable. So the allocation of kids to family, to kin wherever possible, to build family connection, supporting caseworkers to keep kids in touch with their family, recruiting carers who can support with restoration, and then working with our legal team, as we discussed this morning, who have expertise in the children's court and restoration, and practitioners in our operational structure to make sure that we are prioritising as early as possible in the process, ideally before there are long-term orders established. One of the reasons why restoration rates are so low and why PSP has not landed restoration is because PSP is not set up to focus effort on restoration before long-term orders. It's just not structured that way. We are structuring ourselves to make sure that we are positioned to deal with restoration opportunities as early as possible in the process, while family connections are strong.
Thank you. We've got a few minutes each. You go for it.
Thank
you.
Thank you. Just to follow up from questions from my colleague, in relation to the leaving care teams, if a young person is reaching out, is that a call line or is it they reach out to their leaving care caseworker?
Either, Ms. McLaren-Jones.
So there is a phone line that they can reach out to, a bit like Links to Home. And
let me take that on notice as far as a dedicated phone line, but certainly most care leavers know their caseworker that they can call. Obviously, ideally, leaving and care planning should occur or should start to occur from when a young person turns 15. So all of that should be pre-arranged, obviously, ideally helping them celebrate their 18th birthday and moving to young adulthood. But let me take on notice about if there's a specific line.
And can you also take on notice the number of young people between the ages of 15 and 18 that have leaving care plans that are in the care of the minister?
I can probably get that for you now, Ms. McLaren-Jones, if you allow me a couple of minutes.
That's fine.
Thanks.
And in relation to homelessness, I've previously asked about the data sharing between a young person and those young person who's been in out-of-home care or has left out-of-home care that's reaching out to a specialist homelessness services, and the ability to share that information between, I suppose, the different agencies within the same department, but where that's up to.
Yep. So, as I recall it, the More Than Shelter report of the Ombudsman several years ago was the genesis of the data sharing protocol. Work has occurred, and there is, I hope I'm right in saying this, there is a data sharing protocol, that arrangement that is in place. And in terms of specifics, happy on notice to bring back more detail if that would assist. But that report that recommendation certainly has been implemented, and it did take some time due to the data work and tech work around it.
And if you could advise what data is shared and what's reported, particularly, I suppose, then if you're able to obtain the number of young people over a 12-month period that have reached out to an SHS, that have been in contact or that are deemed still to be in the care of the minister.
Yes.
Yeah.
Okay.
Ms. McLaren-Jones, could I come back to your question? Is that okay? So currently 80.1% of children or young people who require a leaving care plan have one. And I can also confirm that there is a dedicated phone line for care leavers. And a shout out to our people who answer those calls and work with care leavers. They're a great bunch of caseworkers.
Definitely. I can agree with that.
Can I just go back to what we were just discussing, Mr. O'Reilly, just in relation to the restoration? Given the lack of success in restorations, and I hear what you're saying about, look, we'll talk to people, we'll take things on outside of the good workers in the department, but to the extent you can only do what the legislation allows. But is there capacity to be looking at new and innovative restoration work? Like, that's your intention, and you will work with people outside of the department to really have those inputs and that feed in.
The strategy that was announced this week talks about a cascading strategy around restoration. This is where we design and commission specialist restoration services, which will then be deployed to case management, whether it's DCJ case management or NGO-led case management under the new model. That will be the purpose of it, and they will be people whose job is restoration. That is the intention of that strategy, and we can't give you the details of it yet, but the design work needs to occur, and we need to consult experts as we do that design work. Internal and external experts.
Yeah, external experts too. Thank you, and all the relevant lived experience and all of that goes with it.
Yes.
Great, thank you.
Okay.
When I was talking earlier about the Office of the Director Legal Services, and you were just referring to all of that work coming into it, is there? Do you think that the team that is led by Ms. Thomas, the principal solicitor in that team, Do you think that that team does have the right capacity for the work that it's doing, or do you think that that is an area that could be bolstered in terms of the work?
I think they're passionate and expert in that work, but I can't comment on their capacity. That's a question for the legal team, General Counsel probably.
Sure.
Can I just add
Yes.
though, Ms Higginson, if you don't mind?
No, please.
A huge regard for that team. Ms Thomas is a proud and very strong Aboriginal principal solicitor for the department, so a call out to her and the team. But we also have to make sure that we have caseworkers who can engage to support and facilitate the restoration activity. The legal aspects are one, but it's actually really intensive work working to restore a child or young person back to their family of origin. The sooner we do it closer to the point of removal also increases the amount of work that has to happen, of course, because you are currently before the Children's Court seeking their determination regarding whether the child or young person should or should not be in care, and then of course trying to continue or build a relationship with the family to then consider restoration. We know that the current PSP contracts allow for fully funded restoration packages, and unfortunately we've seen a decline in those numbers. So part of what we have to do as system steward, which is actually also a core component of the out-of-home care strategy released on Sunday, and in fact late last week, it really is about being clear that our role as government is in fact the system steward, and that we have to be able to create some of these opportunities to facilitate key activities such as restoration.
Okay, all right. So we now have a short break and we will return in 15 minutes.
Okay.
It's me, isn't it?
Great. Okay, we're now back on and over to the opposition.
Thank you. Could I start with, I might just do a follow-up on the Keys evaluation. I just wanted to clarify, I understand that their funding runs out at June this year. Will an evaluation be completed in enough time, I suppose, to be able to ensure that the minister or the government can look at funding moving forward? Because obviously they've got staff and everything else that are concerned.
Yeah, look, at the moment, obviously the evaluation isn't complete, and generally Keys is funded on every year.
Yep.
So obviously if we hadn't completed the evaluation, we'd be looking at opportunities to extend that funding. But certainly my advice is it's likely we'll get the evaluation report by June of this year. We're just waiting on some more data and information from Keys itself.
So the evaluation isn't connected to their ongoing funding at the moment?
Not at this point. And there's two evaluations. There's a thing called statistical evaluation. It's called Stephen. I can't remember the name of it, but we're actually evaluating a range of early intervention programs across DCJ and other government agencies. So that's due in the next sort of month or two. And that does have Keys in it. And then there's a broader evaluation, which I think will be a bit later in the year. So we obviously wouldn't impact on their funding until we'd actually seen what the results were.
Yep. And are there any other evaluations planned for the next 12 to 24 months across other programs?
I think Mr. Riley and the Minister mentioned this morning the ITC evaluation that FAXI are leading with some other researchers. I'm happy to take that on notice.
Yes, that'd be great. Thank you. While I've got Ms. Campbell, just following, just the usual question around the disability homes.
I was
properties.
hoping you'd ask me that.
How many are currently still, or with DCJ, have any transferred to Homes New South Wales?
Okay, so currently we own or manage 803 disability properties.
That's
mostly
less.
group
That's
home.
gone down?
It's gone down by 3, I think. Yes, it was 806 last time. And they're mostly group homes and a small number of respite and day program facilities. As at 31st of December 2025, 691 properties were occupied for disability accommodation or services, which, as I said, was a decrease from the 30th of September of 3. 682 properties were enrolled with NDIS for specialist disability accommodation use through registered providers, and 624 of these properties were actually SDA use. The portfolio includes 12 properties which are owned by Homes New South Wales that we lease for specialist disability accommodation. About 2,500 NDIS participants are residing in that portfolio at any one time, and we've got a budget in the 25-26 budget. There was $3.9 million over 2 years to deliver better outcomes for residents of disability accommodation in New South Wales, and that includes the development of processes to support residents to find and relocate to homes that better meet their needs. As you would know, a number of the properties are legacy properties and not fit for purpose, so we're doing that in a really careful, transitioned way. And I'm just thinking, I know you will ask this question, so it's linked. You always ask me about vacant properties and meanwhile use.
Yep.
So as at the 31st of December 2025, there were 38 vacant properties and 74 currently allocated for meanwhile use to support other New South Wales strategic priorities. So that's an increase of 6 from the last time, from 30th of September. The 74 properties occupied for this kind of use include 61 currently used for out-of-home care, 10 currently used for transitional housing, one's currently used to deliver a philanthropic funded program supporting women exiting custody, which is the Waycheck one, and which is the Women's and Girls Emergency Centre, and 2 currently used for private rental.
Oh, okay. In relation to the transitional housing, is that one, are those in social housing or for people with disability?
there'd be a mixture. Happy to take that on
Yeah,
notice.
that'd be great. And in relation to the 600 odd that are still with providers, are they on a month-by-month lease, or is there 12-month lease on those with providers?
I think the majority of them, and you can correct me, are month by month.
Yep.
So probably similar breakdown to the last time,
Yep.
unless there's anything new.
No, so there's 453 who are on the month-to-month arrangement.
Okay. And then those you're working with to then look at long-term transition potentially as needed. Okay.
Yep.
Yep, that's fine. Now, in relation to the announcement over the weekend, now I understand it's the projects will be delivered over staged 3 stages. So first up is looking at the updates to the way care information is recorded and managed by caseworkers in Child Story and partner community. Has any funding, because I know that Child Story's had challenges over the years, interested to know about if there's any funding that's been allocated to from an IT perspective, because there's a lot of work in that announcement that's around digital work.
Yes, there is funding set aside for Child Story work and as part of it, but we've also accessed the Government Digital Restart Fund to do the initial phase for that project, because it is an innovative piece of work, so that's happening at the moment.
And how much is that?
I can't remember exactly, but we do have the number. I just don't have it on me, but
Yep.
we can come back to you with that.
And is that funding to also upgrade Child Story, or is it purely for or the digital placement matching tool and the care information and the portal?
It's about integrating digital matching functionality into Child Story. It's about integrating it.
Okay.
Yeah.
Okay. I think that's it for now.
Fantastic. Can I just ask about the internal system review into the out-of-home care system that was undertaken in November 2024. That review recommended that there be a comprehensive and independent review of the Act, the Children and Young Persons Act, and the associated regulation, and to ensure the legislation is contemporary, culturally sensitive, and appropriate to address the complex needs of children and young people within the system. What steps, if any, have been taken to expedite the above recommended review by your own staff in terms of that legislation?
So the review of the Care Act, there are changes that are and will be contemplated to that Act, but the view of government is, at this juncture, there's just been so much review happening, so between Audit Office, OMBO, the system review, and the like, and as well probably over time discovery of what other amendments might be. It is not proposed that there'll be an overarching review of the Act at this point, which doesn't mean never, but as I understand the Minister's view of this, there is a need to really make progress on the reforms that we've got, because that is multi-track, impacts a number of systems, and there literally is a point of overload in terms of the amount of work. Having said that, in terms of the more granular and immediate amendments, Mr O'Reilly, is there anything you wanted to add to that?
Well, the work we're undertaking to reform response to ROSH, the work we're undertaking to reform out-of-home care delivery and replacing PSP with a different out-of-home care program, those reform design pieces may require changes to the Act.
To the Act, yeah.
I can't give you any more detail, because those changes will be subject to decisions of Cabinet and Parliament, as you know, but they're the areas where we anticipate we might need to make recommendations
if
to
I
government.
was to suggest the ROSH report found the absence of an explicit link between chapters 3 and 4, and that's the cause of confusion, is that, I mean, that seems to be the flashing light in terms of immediate need for legislative perhaps reform.
Well, that is the Ombudsman's recommendation, but that, again, that's going to be a decision for Cabinet and Parliament, and it's not possible to predict how that would play out. Thankfully, the Ombudsman's report has many other recommendations that are very concrete, and all of those can be implemented within the current, well, we anticipate most of those can be implemented within the current legislative settings, and if we find that they are not, we will make recommendations to our Minister to consider. But the recommendations are framed in two parts. There is the legislation and then there is the policy in the current settings, and that's where all of our focus is currently.
Without telling anyone to suck eggs in the universe, but if there are, if the Minister, and I didn't get a chance to discuss this with the Minister, and obviously I can outside of this session, but if there is, a decision that there is a need to take some of that Ombudsman legislative reform work, just remembering it seems to have been a consistent failure of this government, because perhaps there is a rush and a hurry, but to talk and consult before that draft legislation appears, or as it appears. There's this, in such a sector where there are so many interested parties and so much expertise, obviously within, but also outside of the department, talking to some of the groups that will just be so material impacted and are every day by the legislation, it would be good to remember to always suggest to the Minister, consult. We get those beautiful briefs in our crossbench briefing where the draft legislation comes, and in the very bottom on the briefing it says, who have we consulted with? And you look and you go, oh gosh, not all of those amazing external parties that could be engaged. Anyway,
Ms.
sorry,
Higginson, can I
that
just
was
say,
my platform.
In terms of DCJ, acknowledging the work of PRL, so we have the advantage of, obviously, the expertise around child law and the department's acquittal of its statutory functions, but it also has, probably across government, the most expert group in terms of consulting on legislation, designing legislation, drafting legislation, and they do that work well, and they understand within the sort of parameters of decision making, they actually get that and do it well. And I think the points you make would be accepted. This is an area where expert input actually does count.
Thank you. I just wanted, while we're on the legislative framework, I just wanted to ask about the active efforts, and I may have. Sorry.
The annual report?
Yeah. Has there been... sorry. So there's the suppose to provide a review of the legislation introduced in 2022.
Okay, there were two parts. So Section 266 provides that the Minister will make 5 annual reports on the impact of active efforts.
Yes.
So that first report will be released by June this year. We're working on that now. We were aiming for December, but we have made some child story enhancements that are going to give us some additional data, and we wanted to allow a bit of extra time in order to build up that data. So it could be included in the report. Section 265 provides that we will review the amendments made to the Act to determine whether the policy settings are right. The advice we have gotten from PRL on that is we're going to need about 18 months to complete that review, and that will include a public consultation process as well. So we're just discussing or determining the time frame for that, but we think that could probably commence quite soon, that piece of work. But again, it would take about 18 months. We anticipate.
Are you able, Ms. Jarrett, to comment on whether any of the emerging impacts of the active efforts principles in practice?
Look, I can, and I think it's important to preface that it is, some amendments, new provisions in legislation. Obviously, that is not going to have a drastic impact alone on reducing entries to care and increasing restoration. There are everything that we've talked about today are all contributing factors. But what we are certainly seeing is definitely an uptake in trying to connect families to early legal support, and that's mainly through the LAFPA program, which is the Legal Assistance for Families Partnership Agreement we have in place with Legal Aid and with ALS. We are seeing a steady kind of decline since the provisions were proclaimed in 23 of the number of emergency removals. Not a drastic drop, but a steady decrease, which is a good indication that people are actually maybe slowing down some decision making. And there's also some evidence around people considering alternative legal options to removal, which is a key part of the policy. We also have additional things like the safeguarding decision-making panels that are in place, not an active effort in itself, but definitely a function that really looks at the active efforts that have been applied to families before bring a care application to the court. So those are little pockets of things. Hopefully the data will tell us more and show us more. But we know as time goes on and over those 5 annual reports, there'll be more and more brevity in the evidence, and that will also tie in with the other reforms that are underway as well.
Excellent, thank you. And just finally on this, is there anything that you are aware of in terms of the Children's Court and their uptake in the interpretation and the process for considering the comments that the judges, that relationship to and fro? Is there anything you can comment on?
They're definitely going to be included in the annual report. So we're going to include some perspectives from the President of the Children's Court and the children and some magistrates as well around how they're seeing active efforts play out in court. And the things that they feel like are working, the things that signal areas for it to be improved. Certainly when we were implementing the new provisions, we had a lot of consultation with the Children's Court. But as you would know, the interpretation of legislation is up to individual magistrates, and so it may be applied differently.
And do you think some of that will be reflected?
Some of that will be, we would like to pick that up in the annual report.
That one will be 18 months away.
That's the annual report.
Sorry,
that's the first of 5 annual reports due by June,
and that will be
this
in June.
year.
Wonderful. Okay, great. Look, I have a few more, but I know I can put these. They're not. And they won't be a lot of work, like they really are just a few questions. I can just put them in as supplementary, so I'm very happy because I'm noting. Oh, yeah, did you want to do it? No, I'm not going to. I'll put it in on supplementary. The only thing, there is one more thing I was just going to add, if it's okay. Earlier on, there was the discussion between Ms McLaren-Jones and the Minister, and there was the follow-up discussions about the accommodations that are being uptaken. Is there anything extra anyone wants to say, just in terms of, I'm not going to refer to places, or is it, I think what I'm trying to ask is it fair to say that there are a number of these places that perhaps in the ordinary person's mind, you might say, oh, that's a motel or that's an accommodation holiday place, but that your suggestion is that those places, whilst they're being used for the out-of-home care system, for the provision of care for young people in the system, they are being used, but that there is an additional component to their use, and that is that it's within a family setting. Is there truth in what I've explained?
I can respond to that.
Thanks,
It's not a family setting because it's not their family.
Sorry.
So I'll try and be really clear.
Thank you.
I apologise if this is repetitive, but it is our policy and our commitment that when we deploy an emergency arrangement for accommodation for a child in out-of-home care, we use accredited organisations only. We do not use unaccredited organisations, and we use home-like environments. We do not use environments that are not home-like. Some hotels and motels, etc., include home-like environments in their offerings, and they are the ones that we use.
Thank
Now,
you.
if there are cases where that is not the case, tell me. I'd really like to know the detail of them. But the ones that I am aware of, that I have been advised, are home-like, and the vast majority of IPAs are in nice houses, nice streets,
Yeah.
very well maintained. I've visited many of them myself. But there are times, as the Minister said, where a placement breaks down in the middle of the night and the caseworkers have to find the best they can possibly find for the night, and the next morning they move on to something more suitable as soon as they possibly can. We should not underestimate how difficult this work is. But again, always accredited organisations, home-like environment, sometimes that happens to be in a hotel complex. I think it's pretty clear.
Yeah, thank you. It's abundantly clear now. Thank you.
Can I just, and thank you for that offer, because I do have some where, as I said, caseworkers have raised concerns about them being in caravans and motels.
Keen to know.
So, yeah,
Keen to know
I'm happy
evidence.
to talk to you offline.
Thank you.
Okay, so on that basis, thank you very much. Is there anything that Mr. Tibble, I can see you want to say?
Yes, Mr. Tibble would like to correct something he said.
Thank you.
To your credit, Ms. Higginson,
Yes.
in respect of the police steerco,
Yes.
ALS and legal aid are not
Yeah.
on the steerco, and so you are correct. They are on the implementation and consultation committees. However, more broadly, we will have a look at it and how it's
Thank
working.
you. And you will look at it in the view that I am letting you know that they would love to be back on that steering
Yes,
committee.
I hear you.
Thank you, Mr. Tibble.
Thank you.
All right. On behalf of the committee, we're so grateful to all of you for your time, your evidence, your commitment, the preparation that we know you undertake to come here. Thank you for being here. The committee secretariat will be in touch, as always, in the near future regarding any questions taken on notice and any supplementary questions. So thank you, all of you.
Thank you.
I forgot about government. Always forget. I knew, Greg. I knew.
Better.
I knew there were no